in a matter of Jersey City United against the new ward map versus Jersey City Ward Commission. May we please have appearances of counsel?
Hello, Your Honor. My name is Renee Steinhagen. I'm with New Jersey Appleseed Public Interest Law Center, and we represent the 13 plaintiffs in this case.
Your Honor, my name is Yael Bromberg of Bromberg Law and co-counsel with Ms. Steinhagen on this matter on behalf of the Jersey City United plaintiffs.
Mr. Calderon, you're next.
James Calderon. Yep, James Calderon, representing myself, pro se.
Good morning, Chief Justice Peter Slocum of Lowenstein Sandler on behalf of the amicus American Civil Liberties of New Jersey, Union, Jersey. Thank you.
Good afternoon, Your Honor, and to the rest of the court. Jason Orlando from the law firm Murphy Orlando on behalf of the Jersey City Ward Commissioner and its commissioners, the defendants in this action. Or these actions.
Good morning, Your Honors. Bruce Greenberg from Light to Palma, Greenberg and Afanador in Newark on behalf of the amici City of Jersey City and Councilman at Large Daniel Rivera.
Good morning to all counsel. We'll begin with Ms. Steinhagen, and if you could please identify how you'll be splitting the 30 minutes that you have with Ms. Bromberg.
Thank you, Your Honors, and if I would like to reserve 2 minutes for rebuttal, but I will be presenting plaintiff's preliminary statement and then focusing on the definition of compactness and the the Civil Rights Act. And my colleague Yamberg will present the arguments on equal protection. So this case asks the court to answer a question that has major implications for local elections in New Jersey. Are local officials allowed to ignore the municipal ward law and draw election maps that are not compact, meaning maps where wards are drawn in highly irregular manner that not only look odd to the naked eye, but also fail all statistical measures and tests for compactness? That is, to punish voters for electing candidates not aligned with the status quo. Plaintiffs, 13 community-based organizations in Jersey City representing all 6 wards in the city, submit that the answer is firmly no. Maps must be drawn in accordance with the procedural and substantive requirements of the municipal ward law and established principles of redistricting, constitutionally or otherwise required. Now, specifically, we're challenging the 2022 ward map, which creates boundaries, ward boundaries for purposes of electing ward representatives to the Jersey City Council. All plaintiffs are interested in ensuring that the city is organized in 6 compact, equally populated wards that respect well-recognized neighborhoods, natural dividers such as the Palisades Cliffs, and communities of interest that hold shared concerns arising from their location in the city and cultural and social identities emerging from where they live and conduct their everyday affairs, the place they call home. They are all concerned with empowering the voters of Jersey City, not seeking advantage for any political party or incumbent. And that is what's motivating this lawsuit. Voters across Jersey City were outraged when the commission held effectively only one public meeting, at which time they presented only one map and cryptically stated their reasons for approving the map: to achieve population equality and to preserve demographic breakdown of the wards. And they did not solicit public comment or testimony prior to that one meeting. And it explains the gut punch they felt when they saw that map at that one meeting, with its palpable disruption to the neighborhoods in Ward F and Wards E, in which they reside, with which they identify, and all they know so well. Now, compactness is a standard redistricting requirement. It's universally regarded as anti-gerrymandering standard and a tool to guarantee that communities of interest are properly represented. It's thus an essential factor to be considered, especially in the context of municipalities, where neighborhoods and development patterns define very diverse communities of interest. Now, in their complaint, plaintiffs painstakingly detail how the commission drew a gerrymandered ward map that outright ignores the municipal ward law's compactness requirement, splits historic neighborhoods, ignores natural boundaries, relies on expiring election districts rather than the norms of census tracts, and created 2 wards, D and F, with abysmal scores on two of the most commonly used statistical measures of compactness. Indeed, both wards exhibit grossly irregular shapes, and even the Ward F resembles the Massachusetts district, whose irregular shape in 1812 inspired the gerrymandering. In fact, the REOC score of that original district compared with wards F and D as based on the Law Review article, A 200-Year Statistical History of the Gerrymander that's cited in our brief, indicates that wards F and D are even worse than the original gerrymander, which was 0.289. The REOC score for F is 0.1604, and the REOC score for D is 0.2753. Both the dismal REOC scores indicate real harm to the voters and the residents, to the voting rights of the residents of these two wards, and Ward E, portions of which were merged into F and appended to D. Now, this is only one comparison facilitated by the use of statistical measure used by map makers around the country, including New Jersey, and accepted by numerous courts. Others we set forth in our complaint include a comparison of the plaintiff's proposed map and a comparison with the 200 and the 210 ward maps. Now, these comparisons were only made possible at this stage of the litigation due to the live link provided through Jersey City's website to the Commission's map, which shows the REOC and Polsey-Popper scores for each of the wards and the average score for the entire map, as well as information provided on the Jersey City Open Data website that enabled Catherine Moore, a member of Downtown Neighborhood Coalition who verified our complaint, to generate all the comparative maps attached to our complaint. Now, compactness is thus not a limited value under the municipal ward law, as this court has held in the context of legislative reapportionment, and it definitely cannot be ignored, as defendants have done here. Municipalities have no pre-existing political subdivisions like counties and municipalities to make it difficult to create compact wards. Jersey City historically has had no problem in creating compact wards, and the statutory history of the municipal ward law underscores the importance of compactness. It was deliberately added to the municipal ward law when the general ward law was merged with the Faulkner Act. The purpose of the law was to ensure effective representation of the diverse communities typically found in large urban municipalities. And most interesting, the population deviation in the law was set at 10%, while the New Jersey Constitution requires a population equality to satisfy as much as possible standard in the context of state legislative redistricting. I would argue this shows that the legislature gave a ward commission wider flexibility with respect to population equality so it can enable satisfaction of the compactness ward. Now, this action was brought as in prerogative writ, in lieu of prerogative writ, and we argue it's the same standard of review that typically applies to such actions: arbitrary, capricious, unreasonable, or unlawful. There are explicit statutory standards that are required to be followed. There are established principles of redistricting that the federal courts and this court have acknowledged are relevant to the task at hand. And under the municipal ward law, all commission meetings are to be held in public. A transcript of the hearing at which time the commission approved the map exists, and the commission issued a report of its findings. And in this case, because Jersey City provided a live link to the 2022 ward map, REOC and Polsey-Popper scores for the map are also in this record. And it is based on these dismal scores for wards F and D, below 0.3 using both measures, and below 0.2 under the REOC score for Ward F, and the existence of plaintiff's map, that we believe we proved a prima facie violation of the municipal award, shifting the burden to the commission to justify its dismal compactness scores. As Justice Weintraub stated in Jackman v. Bodine, 55 New Jersey 371 in 1970, when a population deviation does appear above that permitted, the burden is on the state to justify. Now, let me be clear. Plaintiff's map relocates approximately 15,000 less residents than the commission's map. The population deviation in plaintiff's map is 0.78%, which is over 2 times lower than the population deviation of 1.84% in the commission's map. And under both the Popper-Polsey measure and the REOC score, plaintiff's map is significantly more compact, while respecting the historical and acknowledged neighborhoods, Jersey City's geographically based communities of interest, as well as natural borders. It's obvious the commission cannot justify its map with neutral criteria subject to the heightened scrutiny set forth in Karcher v. Daggett, not the rational basis standard set forth by the appellate division. The Karcher standard requires specificity, that a particular objective requires the specific deviations in its map rather than simply relying on general assertions. And it requires proof that there's no available alternatives that might vindicate those goals, yet achieve better compactness scores. The record indicates that the commission justified the map by the need to achieve population equality. Plaintiffs have shown that that goal cannot justify the dismal compactness scores. Plaintiffs have been able to prove their case at this early stage of the litigation only because we had access to the 22 ward map in its original computer format and access to data regarding previous maps, census data, and official maps of recognized neighborhoods, information that most plaintiffs would not have but for discovery. So with respect to future guidance regarding challenges under the municipal ward law, plaintiffs at minimum need access to the redistricting map in the computer format in which it was created. Discovery as to what factors the commission considered if it is not stated in the public hearing or stated in the report. The ability to present testimony regarding communities of interest, including expert testimony regarding possible alternative maps with better compactness scores while achieving population equality and preserving communities of interest, all of which was wrongly denied by the appellate division. That said, because defendants in this case decided not to answer plaintiff's complaint, deny our allegations regarding statistical measures, and fight this matter factually, but rather they decided to assert that as a legal matter, population equality is all that matters, and compactness is satisfied when population equality is achieved, and that they do not have to consider communities of interest. We believe that this court can find this map invalid on the record before it. Defendants' total disregard for compactness, a factor that's essential to satisfy the goals of the municipal award law, to secure fair and effective representation, and to prevent voter dilution, calls for a remand to the commission to draw the map under the guidance of a special master and the directives of this court to consider compactness independently from population equality and to consider communities of interest as part of that analysis. Given that the entire Jersey City Council will be elected in November 2025, with candidate petitions being issued within months, and they are due in June 2025, this matter should not be remanded to the trial court to permit discovery, the presentation of expert reports, and a full trial on the merits of this case. Why? Because it's clear the 2022 map is irrational and violates the compactness requirement of the municipal award law, the Equal Protection Clause, and the New Jersey Civil Rights Act. So I would like to then move on, if you want to start asking questions or just to discuss more in point what we think should be the definition of compactness.
So can you focus with us on the specific language of the statute, which has three requirements, as you know, compactness, contiguity, and nearly equal population. Tell us how and where the statute calls for consideration of communities of interest.
Okay. I think the statute itself, because it does not define the term compactness, does not call for the considerations of communities of interest. Rather, the statute embodies the traditional established principles of continuity, contiguousness, and compactness, which is also in our Constitution. And as you do know, that in our Constitution, communities of interest are a traditional concept of redistricting. Now, I would like to pose to this court the failure of the appellate division to go beyond the common language use of the term compactness doesn't help us understand what compactness should mean, how we can operationalize it, and understand the goals of compactness. Now, we do know that in Jackman
If I may follow up, so it's not in the statute.
It's not in the statute, and that is
What
correct.
what is a community of interest, and give us the authority for your definition of a community of interest? Because I frankly think it has been presented as a number of different considerations that may make it difficult for a workable standard to be developed.
Okay, Your Honor, I don't want to avoid your question here, but in fact, Yael Bromberg is going to focus on communities of interest.
I thought she was handling the equal protection aspect.
Well, but the equal protection
Yeah, I understand it.
analysis is,
I understand it's relevant to the equal protection analysis, but it's right on point, respectfully, to what you've just been arguing. Because you were telling us that we must, in interpreting the statute, consider communities of interest. So what is the definition? And I may ask it later, or someone else may ask it later for your colleague. What is the definition of a community of interest?
I will, again, I don't want to defer. I want to give you a definition of compactness that will show that a proper definition of compactness does encompass effective representation.
Respectfully, counsel, that would be fine, but I'm asking, you've based your argument on injury to communities of interest, historic neighborhoods, et cetera. I'm simply saying, what is this thing that you are calling a community of interest? That's all I'm asking.
I will do that, and then it will be further discussed by Ms. Bromberg. A community of interest is defined by, typically now, it could be it's most typically defined geographically, that it's a geographical community that because of its geographical community shares concerns that can arise from the infrastructure, can arise from where they live, and it can arise from demographics, racial demographics, or social and cultural identities. And and Ms. Bromberg will go further to articulate that.
Let me just follow up on that. So does that mean that if a community of interest is to be gauged based on geographic considerations, and you mentioned that may bring with it cultural history and communities of or common interests that people have, are you agreeing that we should look at that consideration primarily through the lens of geography?
Steinhagen, before you answer that question, hold. Justice Winter, after we can't see you, can you hear us?
I can hear you. I'm having a problem with my video and I apologize, but I can hear you.
Wonderful. We'll continue then. Ms. Steinhagen.
My answer would be yes, within bounds. I don't want, for this case, the answer is solely yes. But it's my understanding that people who, in redistricting more generally, not outside of the municipal context, do not see communities of interest necessarily tied to geography. However, I will make clear, communities of interest as they arise within the Voting Rights Act has made it very clear that even when they are considering communities, they must be reasonably compact. And I would argue that a proper definition of compactness implicitly implies that people are living within proximity to each other, that they can arise similar concerns, whether it's based on housing patterns, pollution in the area, or social and cultural identities. So for purposes of municipal ward law, I would say the answer is yes.
Counsel, when you say your definition of compactness, because I'm trying to understand as well how communities of interest is encompassed within the compactness definition, and you just said it includes people living close to each other. What people are you talking about? Because if we're looking at compactness geographically, then those people live close to each other. Are you specifically referencing individuals who share cultural, racial interests or interest with regard to the area specifically where they live? Like what does that mean? That compactness of people living near each other, what people are you referring to?
I'm talking about the residents in a geographical area. I think that's what's the assumption behind the notion of compactness, and why compactness historically has been associated as the best way to secure communities of interest. That doesn't mean that in some cases, the lack of compactness can be shown in a specific situation that there might be a community of interest that doesn't fit within it. But I would argue, and we as plaintiffs have not specified a definition of compactness, other than in our appellate brief, we list in a footnote how other states have defined it. So I am ready at this moment to give you what I think is the best definition of compactness, and a definition that in itself shows that the analysis of compactness requires you to take into consideration communities of interest, because it in fact assumes it. It assumes the
Counsel,
notion.
I'm confused, counsel, as to, so it seems like you're saying communities of interest are defined geographically. And earlier in your argument, you also referred to the fact that you're alleging that wards D and F are precisely the types of, you called them gerrymandered districts that created the term gerrymandering 200 years ago. And you talked about how the Massachusetts district that created that term actually would have done better on statistical measures than either D or F. But then it seems like you criticized the appellate definition of compactness, where they cited a dictionary to establish that the definition of compactness includes having a dense structure or parts or units closely packed or joined and occupying a small volume by reason of efficient use of space. So I'm not clear as to why you are opposed to that definition, if it seems like it is the definition you're giving, but just with different words.
All right. We actually offered that common usage term to the appellate division. I think it's fine, but I don't think it's sufficient to actually define compactness. It does not go and tell us what compactness means in the context of redistricting. Similarly, in the appellate division in Davenport in 1973, the appellate division attempted to give a better definition of compactness. It started too with a common usage word of defining compactness as marked by concentration in a limited area. We agree with that. We agree with that. But it went on to technically, we interpret the requirement of compactness to mean that between two districts of equal area, the one with the smaller perimeter is the more compact. And it went on to offer another statistical measure. Now, though that case was reversed by the Supreme Court, Justice Pashman, in his highlight in Davenport, said, I think the appellate division's explanation was as good as any. Now, I will say we believe that this too is not a sufficient definition of compactness. It clearly, as Jackman just relied on subjective visual notion, not even of compactness, but of non-compactness. The appellate division's definition here equates the concept with two statistical measures that were circulating at the time. The first was introduced by Joseph Schwartzberg in 1966, and the second by Ernst Rioch in 61. They were both presented in law review articles cited by plaintiffs. Now, Schwartzberg proposed measuring compactness by using the ratio of the perimeter of a district to the perimeter of a circle with the same area as the district. Palsy Popper modified that in 1991 by proposing comparing the ratio of the area of the district to the area of the circle, whose circumference equals the perimeter. Now, they stated their statistic was mathematically equivalent to Schwartzberg, and both have been identified in court cases and in the literature as perimeter measures that are sensitive to irregular borders and elongated districts.
Sorry, but you just mentioned our opinion in Davenport, and specifically this court in Davenport wrote that compactness is an elusive concept. It may be of limited utility in creating legislative districts in the light of the odd configurations of our state and municipalities. It has never been held to constitute an independent federal constitutional requirement for state legislative districts. And this court has suggested that population equality is distinctly paramount to it. So I'm not sure why you would say that Davenport, are you saying that Davenport is a better definition of compactness than the Aptiv's plain meaning definition here, where Davenport specifically seems to say you can ignore compactness and it's of limited utility?
I said the appellate division case in Davenport, which is 124 New Jersey Super 30.
Understood, but of course we would have to look at our own opinion in Davenport, which came after the appellate division.
I understand that.
Correct?
I understand that. And I said that there was a definition offered in the appellate division. The Davenport decision rejected the consideration of compactness. It did not specifically reject that definition that was offered in the appellate division. And I started out by saying Justice Pashman, in his dissent, who thought that the court was undermining the value of compactness in state legislative redistricting. And I am not here to contest that the limited value of compactness in state legislative redistricting. He said he thought that definition that had been offered in the appellate division was as good enough as any. And I am just saying, I'm as a starting point here. We're not talking about the value of compactness. We're trying to define compactness here. And I believe that by just using common usage terms in the dictionary, without putting that in the context of redistricting, that's not sufficient. This court can do that, but I don't think it's sufficient.
Okay,
And
so
what
what
I
is
was-
the definition, I'm sorry, that you would ask us to apply? A concise definition of compactness that you believe this court should include in an opinion?
Okay, I believe that the definition of compactness that should be used is the one that was adopted by the Colorado Supreme Court in Acker v. Love in 1972, which is cited in our 2021 Colorado Supreme Court case, that it's in our appellate division brief at 819. Compactness
Sorry,
concerns.
can you give the citation first and then provide the actual definition?
The citation to the Acker v. Love is 496 Pacific 2nd, 76, Colorado, 1972. It is continually cited. It's also cited in the 2021 Colorado Supreme Court case that is in our appellate brief at note 8, page 19. Compactness concerns a geographic area whose boundaries are as nearly equidistant as possible from the geographic center of the area being considered, allowing for variances caused by population density and distribution, census enumeration districts, and reasonable variations necessitated by natural boundaries, and in the context of legislative redistricting that was there, by county lines. It too, this definition can be operationalized by the Rioch and the Schwartzberger ratios, which is exactly what the Colorado Supreme Court did in 1992 in reapportionment of Colorado General Assembly 828 Pacific 2nd, 185, 195, 96, Colorado 1992. This means with this definition that can be operationalized by using the statistical measures, compactness is no longer solely within the eyes of the beholder, subjective assessment that's given way to statistical measures that permit a court to evaluate a district's degree of compactness with the same precision that it evaluates a redistricting plan's degree of population deviation. That was done. Karcher v. Daggett tells us that was the purpose. Recent Supreme Court cases that have adopted such a definition and the use of these two statistical measures as a way to operationalize compactness are the Harper v. Hall, North Carolina Supreme Court decision in 2022, and our next door neighbor.
Under these statistical measures, there's no actual measure of compactness, right? I understood from the statistical measures that they provide numbers between 0 and 1, but they don't say, for example, if it's less than 0.5, it's not compact. If it's more than 0.5, it's compact.
Yes, they are comparative. They allow people to do a comparison of a district is more compact than another district. There have been recommendations that Rioch already did in 1961 when he introduced the concept, that there's a sense that we're looking for reasonable compactness. As we know, the voting rights jurisprudence all requires, when you're creating a majority-minority district, that it has to be reasonably compact. So I would argue that there's an assumption of reasonable compactness to be sufficient. And I accept, taking the Rioch scores and the Palsy Popper, that anything above 0.3 gives us a presumption of reasonableness. That doesn't mean that some plaintiff might not be able to show, if they can prove impermissible factors, that even such a ward or a district that is above 0.3 is compact. They can prove maybe that the map is invalid for other reasons. But the 0.3 is a beginning point to argue anything above 0.3 can be presumed to be valid, and anything below 0.3 can be presumed, well, REAC puts a little other measure. He says below 0.3, we really got to look at this to make sure that it's not, that there's not an impermissible motive going on here, that it can be justified by neutral criteria. He goes as far as to say that anything below 0.2, such as something like Ward F, is presumed to be not compact and invalid.
The legislature presumably has the authority to create those presumptions. And yet in a case in which there's not a constitutional aspect to obviously the statutory, you're dealing with the statutory interpretation part of this, the equal protection is separate. You're asking us to create very specific presumptions based upon methodology that is nowhere in the statute. Well, how and why should we do that?
Well, there's the statute is the statute, and then there's been what courts have been doing around the country. And what's very clear, just as you did in Jackman v. Bodine, when the standard was at that point, as nearly as possible, the population deviation, there's a notion that certain deviations cannot be accepted, and that would shift the burden to the state to justify it. Look, if you don't, one does not even have to put or impute that the goal of a court when faced with a statute that just requires compactness, that's not qualified, is to argue and to determine whether the map is sufficiently compact. And we are arguing here, plaintiffs have shown that we can create a map with better population deviation that has much better compactness scores. That alone should trigger the need for the state, or in this case, the commission, to justify why it created a map that had low population scores.
But your presumption there is that the scores are the definition of reasonable or sufficient compactness. And we have from the legislature no definition that implicates those scores.
The appellate division actually created a definition that embodied those scores. It equated the definition with those scores. The definition that I have given talks about, I think, the reality of redistricting and allows one to operationalize that definition by using the measures. And that is exactly what the courts have been doing. The courts have been doing it.
With regard to the definition of compactness that you provided from the Supreme Court of Colorado, you've indicated that the appellate division's definition is insufficient. You are arguing that the scores should be a driving force with regard to compactness. That's what it sounds like. But you've also argued that communities of interest need to be considered in making a determination of whether a ward is compact. So I'm having trouble understanding the concise definition of what you believe compactness represents, because in looking at the definition of compactness from the Supreme Court of Colorado, I'm not seeing where your argument that communities of interest plays a role in that definition. I don't see that in the definition of compactness you just gave, but earlier on in this argument, it sounded as though you were making the argument that communities of interest is encompassed within making a compactness determination. I understand Ms. Bromberg will expand upon the communities of interest, but that seems to be your argument, that compactness includes communities of interest, but also seems like the scores, the population density, all of that is also encompassed. Your definition doesn't seem to include room, from what I can tell, for the communities of interest. So where is that in your definition that you're promoting?
Okay, thank you. I have to just say the appellate division, I just to in your answer, I think it's fine, but I think it actually just equates the definition of the compactness with the scores. I take the position, the Colorado definition, as well as the appellate division, because the scores themselves that I believe operationalize the definition, they all are designed to secure voters' effective representation. by implicitly recognizing that the more densely located a representative's constituents are, the easier it is to travel across the district and to physically engage with the voters of the district, as well as it is easier for voters to communicate with one another and politically cohere around shared interests arising from their physical proximity to one another. That is the community of interest. That is the community of interest that I feel is appropriate to municipal ward law. I do not want to be making statements about communities of interest more generally. We understand that there are groups, there are people who take the position that communities of interest are not necessarily tied to physical proximity, though there is strong evidence and a belief, and I believe very, at least valid in the context of a municipality, very clearly, that the closeness and the proximity, the sharing of the same housing infrastructure that has been determined mostly by economic concerns and zoning in these municipalities has created those districts and has created those communities of interest. We are not imposing a community of interest. We are taking neighborhoods as the community of interest that needs to be protected in Jersey City. Neighborhoods that have been formally recognized in Jersey City's own data, their own maps that their planning department has created. And why is that the case? Because these advocacy, the fact that my plaintiffs represent grassroots community groups, neighborhood-based community groups, only 2 of the groups that I represent are citywide. The rest are all based in their community. Their advocacy, their being is about is a political cohesion around shared concerns that they have in their community. And that's the community of interest that I think is implicated.
Council, can you tell us to what extent you're relying on the legislative history and what aspects of it? And as you do so, help us understand the import of the sponsor's statement to the MWL, because it's very specific. It says the bill would implement recommendation number 6 of the Musto Commission report, that existing ward laws be updated and consolidated into a single uniform ward statute prior to the 1980 census. It doesn't adopt any other, it doesn't seek to implement any other recommendations of the Musto report. How does the legislative history advance your argument?
The legislative history, if I understand it, also recommended that they adopt compactness. The original general ward law that was merging with the local public municipal option law, the Faulkner Act, the general ward law did not have a compactness requirement. And they specifically added the compactness requirement into the ward law.
What aspect of the legislative history are you referring to in that answer? Is it something beyond recommendation number 6? Because I'm grappling with the specificity. The sponsor says, this is all we're trying to do. How do you address that?
Okay, I will get you the exact page number in the legislative history. There's a comparison of the old ward law, the Faulkner Act, and what the new ward law is. It's PA 80.
Is that part of recommendation 6?
I think it's part of the, it's part of the report and then the statutory provisions and the recommendations. And though it might not be highlighted that that's what they did, it is part of the recommendations that they actually incorporated the they incorporated format of a compact territory, which was in the optional municipal charter law.
So there is much in the legislative history, and I recognize that, and you've made that point as well. Here we have a sponsor statement that says, this is what we're seeking to do. We're seeking to implement one thing, recommendation number 6. What are we to make of that and its import on the balance of the legislative history?
I'm going to tell you, I'm not going to fudge this here. I don't know what specifically recommendation 6 says, other than I do know that they created a uniform law. And in that uniform law, they adopted the compactness requirement that was in the Faulkner Act that was not in the general ward law. And then in the statutory history as to why they did so, they emphasized that this was necessary to do so in the context of giving representation to diverse communities that exist in larger urban areas. And that introducing wards into smaller homogeneous communities would create unnecessary fragmentation. And it is this reliance on doing it within diverse communities. And also in that history and explanation, it makes reference to recent court decisions that talk about the importance of giving a voice to diverse communities. And at that time, this was in 1981, in 1980, we had a case in the city of Mobile, and a Voting Rights Act case in Alabama, that had denied the ability, it was a challenge to a at-large system, and had denied the creation of wards to represent the diverse community. In that context, in the context of a VRA challenge, it was a racial community in the city of Mobile.
Let me help you with recommendation 6 and then ask if I understand your answer correctly. It essentially recommends that the general law for redrawing wards and the optional municipal charter law should be updated and consolidated into a single uniform ward statute. That's recommendation 6, the text of it with a few words left out. Are you telling us the reference to, your position is that the reference to a uniform ward encompasses everything else in the legislative history? A uniform ward statute?
I would say, I'm going to say yes, but here they're creating one statute, one uniform, and they chose to incorporate the compactness requirement that was in the municipal ward law, which was in the Faulkner Act, which was absent from the general ward law. And they did that because of the inherent nature of compactness being required to secure a fair and effective representation of diverse communities that exist in larger urban areas. And
Sorry, I
though,
want to make sure I understand. You're saying that regardless of what the sponsor statement said about recommendation 6, what they actually included in the law is the requirement that the wards be compact, and that a prior version of the law had not included that requirement.
I don't say it's regardless. I read what Justice Rabner just read back to me as saying that they created a uniform statute. They merged 2 statutes and they created one statute that would guide redistricting for municipal wards in all municipalities, not just Faulkner Act. The local municipal, the Faulkner Act just governed certain communities in the state, and they tend to be the larger communities. There's no doubt about it when one looks at who is governed by the Faulkner Act. So I don't see it as inconsistent. It's just not explicit. I think the idea here was to create one uniform ward law. And implicit in that, when they chose to create that one law, they chose to include the compactness requirement that was in the Faulkner Act, which shows the
But
importance.
that's not implicit, that's explicit, because the law actually does include the word compact.
Correct, but I guess I'm not understanding your question. I thought you were saying that I was denying that the purpose was to create one ward law. It's by the if I'm understanding what Justice Rabner read me back, the purpose of the law was to create one uniform law. That's all it says. Implicit in that, when you look at the law that they created, they included the compactness requirement that was in the Faulkner Act. So in effect, they also included the publishing requirement that was in the Faulkner Act. What they basically did was they created one law and they put the standards in.
Language. I mean, that is in the statute itself. The compactness requirement and the publication requirement are both in the statute. But in terms of looking at the Musto Commission and the recommendations of the Musto Commission, other than recommendation 6, are we to infer that those recommendations were also intended to be incorporated into the law?
I believe when they intended to do, yes, I would, if they were approving, if the Musto report makes the recommendation to adopt the standards that were in the Faulkner Act to the One Uniform Act, and in that sense, yes, I would say that
But-
the legislative history shows that.
But are you arguing that the whole Musto report is part of the intent of the legislature in enacting the statute?
My understanding is that it was included and attached when the Musto report came up, when we did the statutory history. It wasn't like we went and found the Musto report. The Musto report was attached to the legislative statements, is my understanding, and in thus way, the Musto report was incorporated. I also have to say, though alive at the time, was not in New Jersey and did not know, but Ernst Rioch's name is all over this. Mr. Rioch is all over redistricting in New Jersey. As the footnote in Karcher v. Daggett shows us, he was producing alternative reports that were being submitted to the court that had compactness scores that were better than those that had been proposed. So my understanding is, yes, the Musto report has been incorporated. That's my understanding, was that it was incorporated in the legislative history that followed this passage of this uniform law.
If we could go back to the statistical analysis that you've referenced, you started off by saying that the scores indicate failure. You then said that there was a 2.5 or 3, a number 3 score that you thought would indicate that it was unsatisfactory, but those are absolute scores. So isn't the question really, what is the score relative to the score that would have been provided that ward prior? And if that's as opposed to what its absolute score is, and because we're looking to see whether the ward became more or less compact. So it seems to me that the scores are only relevant if they're judged relative to how the ward previously was configured. If that is the case, what would your standard for, and I'll call it material decompaction, right? What would your standard for material decompaction be when you're comparing one ward relative to the way that ward used to be? Because you could have a situation in which a ward that was never challenged actually becomes more compact. But if you're just looking at absolute scores, you could say they fail, which would be a really odd result. So viewing them as relative to what changes were made, what is your standard for what material decompaction would be?
The reality of compactness as a term and how it's used in redistricting is a comparative one. And I would not say that the only comparison you make is from a ward in one map to what that ward was in the other map. There is no doubt that I think part of an understanding of comparing maps, and in this case, you're asking me to compare a map to its previous, which we did compare this 2022 ward map to both the 2010 and the 2022. I think our comparison to the past was really to just show that compactness is feasible in the context of Jersey City. Now, a map, there's a fluctuation. For instance, in our map, we are comparing our map to their map. We're comparing
your map, your proffered map right now is really not where my concern is. And because we could all draw thousands of maps that could come out different ways. So let's keep the focus on what happened here. And I just want to understand the answer, which is you threw out some numbers before as to what you thought would be thresholds for insufficiently compact wards. If you're comparing a ward to the prior ward to see if it was made more or less compact, what would your threshold be in determining whether a ward has been made less compact?
A threshold is just that if it has a lower Rioch or Pawsey score.
So
the reality is that's not the end of the analysis.
Anything lower would make it materially less compact?
No, not
Actionably
materially.
less compact?
No, I would not say materially less compact. As I said to you, first of all, I'm not sure you can in the context only look at each ward individually. You have to look at the whole map because it influences, each ward influences, even though the requirement in the in the municipal ward law is that each ward is compact. And I would argue reasonably compact or sufficiently compact. Now, compactness, you have the definition. We do believe it's a geographically based definition. It does encompass this, what we offered does talk to you about what the goal of it is to get effective and fair representation. Now, how do you operationalize that? You use these scores and you do a comparison. You do a comparison of the overall median compactness score of all the wards, and then usually you do the one with is the minimum. Now, as I said to you, the starting assumption seems to be, now again, some people don't like, REOC is very sensitive to the shape of a district. Policy Piper is very sensitive to the jagged edges or the boundaries of the system. So as you see, you know, the REOC score, so they measure sort of different things, but what are they all trying to do? They're all trying to make sure that the map makers did not use impermissible factors here, that they used neutral criteria. And so to answer your question, I can only go back with what I said in the context of REOC and Piper Palsy. I think there's a presumption of a validity of any district, presumption of a validity, that anything above 0.3 is presumed to be reasonable and valid. That doesn't mean, so then if you have scores below that, they require you to do an analysis and look at all sorts of things, such as population deviation is the main thing that you have to look at. So the point of the matter is, in this particular case, there are scores, not just the scores operationally, but also visually. I'm not saying that you can't use visualness. We're not throwing Jackman v. Bodine down the drain. I have to tell you, that Jackman v. Bodine decision that said non-compactness is bizarre designs appears in almost every case early on in other parts of the country at that point. Everybody was struggling with the notion of compactness, and every district was struggling with how compactness can be met when they got the one person, one vote, Reynolds v. Sims situation, and it became a real problem in the context of county lines. And in our case, in those state legislative decisions, constitutionally, you have to keep the municipal lines intact. So all I'm saying is compactness is a standard that I believe the legislators in the municipal ward law thought was essential to making sure that there was fair and effective representation, especially in the context when you wanted to preserve and give representation to diverse communities that were most likely geographically located in proximity to each other. Due to economic issues, neighborhoods develop over economics, neighborhoods develop over ethnicity and race. Neighborhoods develop in municipalities primarily due to the master zoning plan and how things have happened. In this case, I will just get you back to facts. F was Morris Canal, the old industrial site. And what that community is facing is low-rise residential housing and enormous population difficulties. Remediation has been going on in that community for a very long time. Now you take Ward F, where a lot of Ward F was put in, Ward E that was put into Ward F. That was the old rail yards. They were empty. There was no housing. We have high-rise luxury housing built with high-income people. The reality of this city is that they created an incoherent ward, a totally incoherent ward. And I wasn't going to mention it. I moved from New York City and live in that ward now. I learned that ward. I live in that high-rise luxury on the water. And I walk to meet my client. I walk. We're talking about two different communities, completely different based on infrastructure. The concerns, no one in my community is concerned about parking. No one in my community is concerned about schools. No one in my community. So I just want to say, to get back to your answer.
I'm very sorry to interrupt you. And my clock could be wrong, but it suggests we've got a little bit over the 15 minutes you had asked for. Justice Hoffman, did you have any follow-up questions?
No.
And any other questions from members of the court? Let me ask you to please sum up your argument, and then Ms. Bromberg, we'll turn to you before we break.
No, I think I've done it. I don't want to repeat. I think we've offered a definition of compactness that is more than just the common usage of the term. It's in the context of redistricting, and that the goal, taking this notion of compactness, of equidistance from a core center, takes in the notion of effective representation of communities of interest that develop around that, and that around living together, sharing these cultural or identity together, in this case in neighborhoods, and that can be operationalized by using these statistics, and that the statistics don't offer absolute numbers, they offer ways of comparison, though visually, I do think that one can take any statistical measure below 0.3, both for the Pipe palsy and the REAC score, as presumptively not reasonable.
I have one question that I think can be answered very quick. You said that REAC is all over this. Was the REAC statistical model around at the time the municipal ward law was adopted in 1981?
Yes, he wrote
Thank
the
you.
article in 1961.
Thank you. Ms. Bromberg.
Good afternoon, everyone. Thank you. I'll focus on the equal protection arguments, and particularly as they've applied over time to acknowledge both compactness in the equal protection jurisprudence federally and in New Jersey, as well as communities of interest as an aspect when considering compactness and weighing the various traditional redistricting criteria. The New Jersey and federal courts have always upheld traditional redistricting criteria of population equality, compactness, and the value of communities of interest within the context of equal protection. A violation of any may give rise to an equal protection violation. Here, the commission report did not take compactness into account. It didn't even reference it as it applied it when redistricting in its report. And in the papers below, the commission repeatedly argued that it satisfied compactness ipso facto via the population equality criteria, although we know that those are separate factors that are required by the municipal ward law as informed by the foundational equal protection jurisprudence. More, the commission altogether ignored communities of interest, and in its briefing, dismissed the value of that criteria altogether. These omissions and admissions alone are sufficient for this court to invalidate the map as irrational and to remand for a new map to be drawn with a special master. Yes, as Justice Apner mentioned earlier, following the reapportionment revolution, the state and the federal judiciary grappled with how to satisfy the criteria of population equality, given the regard given to respect political subdivisions, particularly counties, in the line drawing process. And specifically in New Jersey, the context of how New Jersey's 21 counties, how one can draw lines without upsetting those county political subdivisions while managing the different population densities among the counties. And it was impossible to do so. But even then, the court consistently acknowledged that maps could not tolerate bizarre shapes, such as a shoelace and a horseshoe. Those shapes are similar to the jagged L shape and the crab claw presented to the court today. However, the New Jersey Supreme Court has never strayed from the fundamental guidance of Reynolds v. Sims set forth in 1964 by the United States Supreme Court with respect to the equal protection pursuant to the 14th Amendment, nor its application to the purpose and the goal of redistricting, which is fair and effective representation, taking into consideration the weight of the votes, the geographic residencies of voters, and communities of interest. Actually, the New Jersey Supreme Court waited until the issuance of the Reynolds decision. Yes, Your Honor.
Counsel, is there any federal constitutional case that imposes compactness as an independent federal constitutional requirement that is not simply intended to focus on whether there was a violation of one person, one vote, or whether there was an instance of racial gerrymandering. So I understood your complaint to not raise a claim of racial gerrymandering or partisan gerrymandering or any violation of the Voting Rights Act. So my question is, for constitutional purposes, are there federal cases that say it is a separate requirement of the federal constitution that wards or districts must be compact, having nothing to do with racial gerrymandering or one person, one vote?
These cases come through the evolution of the right to vote and the equal protection. They come through an arc. Originally, it was due to the reapportionment revolution of Reynolds v. Sims. And then it translated to considerations of minority vote dilution, then to racial gerrymandering, and then eventually to partisan gerrymandering, which is now sent to the states to offer the standards for. So I think that the question is, there has been an evolution of removing the racial aspect when considering partisan gerrymandering, Your Honor. But the compactness principle, you asked for a specific case. The LULAC case offers a bit of guidance on this, because there it did come up under the Voting Rights Act jurisprudence, claims and related constitutional challenges. But it's an interesting case that was presented because the lack of compactness could not be justified by the disparate communities that were drawn. And specifically there, although the district had been drawn to basically consolidate the Hispanic vote, the Supreme Court invalidated it, finding that the specific neighborhoods, the specific communities of interest within the Hispanic communities did not satisfy the requirement for vote under the voting rights analysis. And I think just adding a little bit of flavor, texture to that will be helpful. Specifically there, the Texas legislature drew a line around that included the Hispanic communities adjacent to the Mexican border with the Hispanic communities within the city of Austin. And because the district had a low compactness score, it could have been justified. The low compactness score could have been justified had it included communities of interest in a way to satisfy their political equality, fair and effective representation. But because the communities of interest there were so disparate, and the language is actually very helpful, including for our purposes today in analyzing what took place in Jersey City, in Ward F in particular, and Ward E. In LULAC v. Perry, the Supreme Court invalidated race-based districting, which did not sufficiently take into account communities of interest.
But again,
there the court found—
I think that's answering my question in a different way, in that the claim in LULAC was one of race-based discrimination or racial gerrymandering. My question is there any federal constitutional requirement that compactness not be looked at to say, was there something else at play like racial gerrymandering or racial discrimination? And instead, compactness is now an independent requirement that has nothing to do with racial gerrymandering or race discrimination, because in this case, there is no claim of racial discrimination or racial gerrymandering or even partisan gerrymandering, which you also mentioned, correct?
Race-based gerrymandering and invidious discrimination is not necessary to find a violation of the equal protection jurisprudence. And you can see that clearly in the one person, one vote. The one person, one vote
I understand, but obviously
challenges.
here there's no one person, one vote violation either, because the, wards were redone so that they're the exact same number or very close to the exact same number of people in each one. So that's why my question originally was, is there any federal constitutional requirement that sees compactness independent from either a one person, one vote violation or race discrimination or racial gerrymandering?
The difficulty, frankly, that I'm having with the question is that all of these aspects are traditional redistricting criteria, and they are meant to balance from each other. So if you were to, for example, offer a different gradient on population equality, it would be for the purpose of increasing compactness. And if you were to offer a greater variation on compactness, it would be to satisfy the communities of interest requirements. So all of these are inherently a part of each other. And I would like to note is that, yes, the complaint is devised based on a violation of municipal ward law and equal protection, which includes the equal right to vote. But here, the map that we produced did have a lower population deviation while satisfying compactness and while satisfying communities of interest. And so this range of traditional redistricting criteria are meant to be, as Judge Karchman advised during the last redistricting cycle, they're interwoven. So removing one to ask, for example, can compactness be an independent? I suppose so. I mean, that's what the principle of the minority vote dilution analysis looks at. However, all of these factors are required and they're interwoven and inform each other. And this is all, I want to go kind of bring it back and bring it forward to the analysis, the discussion at the moment. In Jackson v. Bodine, the New Jersey Supreme Court held its decision until the issuance of Reynolds v. Sim, and Chief Justice Weintraub acknowledged that an individual's right to vote is unconstitutionally impaired when its weight is in a substantial fashion diluted when compared to the votes of citizens living elsewhere. And specifically, the New Jersey Supreme Court acknowledged the community of interest.
You're not making a dilution claim here, though, are you?
These votes were diluted, Your Honor. The votes of the residents of Ward F, for example. Ward F, I'm jumping around here a bit, but I want to...
You're not claiming any racial dilution in this case, are you?
The claim is not a racial dilution claim rather, but Your Honor, Ward F.
It's also not a Reynolds versus Sims claim, which is about one district having 100,000 people and one district having 10,000 people, so that one person's vote is not worth as much as another person's. Here under the commission proposal, it looks like the largest, the difference between the largest and the smallest ward is less than 1,000 people, correct? Something like 48,311 to 49,211. So 900 people is the biggest difference.
The one person, one vote jurisprudence board came out of the equal protection principles for fair and effective representation. Ward F had 6,000 voters moved out of it into Ward B. It had 9,000 moved into Ward A. And so it's essentially moved out 15,000 voters, residents, while importing 15,000 more from the luxury high-rise buildings made of what's called the Gold Coast, right?
But Reynolds versus Sim didn't specifically speak to that, right? It didn't specifically speak to a general concern with effective representation. Instead, it spoke to a constitutional requirement of one person, one vote. And that's what created the whole revolution in voting rights cases about one person, one vote.
These are actually related to each other, although we've given them labels such as one person, one vote as a label. The reapportionment revolution came about because the legislatures had in some cases waited decades to offer population equality among their districts. What is population equality and why is it important? It is how voters and residents can self-organize to effectuate effective representation. So if you remove, and I know we talked about the mathematical quantitatives earlier, but if you simply, I want to kind of get a little more abstract from that. If you remove from the abstraction of these population deviation, and even when you are, by the way, within an acceptable range of population deviation, the burden shifts to the state to explain why you didn't go lower. It's not simply accepted. And that's actually a critical aspect. It's not simply accepted that when you're within the acceptable range of deviation, you can rubber stamp it and say, this is a permissible map. You still have to explain why you didn't go lower, if it was possible for you to go lower. But going back to the question about effective representation, the language in Reynolds v. Sin, yes, it's about one person, one vote and the reapportionment revolution, but it was about citizens based on their geographies being able to represent legislators to advance their views fairly and effectively. And in Ward F, this is a community that had extreme environmental devastation. They've had a long cleanup, remediation cleanup. One of our plaintiff organizations organized on the local, state, and federal level to ensure the cleanup of a chromium contamination site that was endemic to Ward F. They self-organized for this. They beautified and invested in their own neighborhood. Yes, they're primarily a Black and Latino neighborhood. That doesn't necessarily mean that we're raising this challenge under racial discrimination. We're raising the challenge because as they invested in beautifying their neighborhood and ensuring affordable housing, that they could continue to live there and have a representative that could affect their views and their unique community interests, that they were turned around and they were gerrymandered. 15,000 residents were moved out of it and 15,000 others were moved in. And they have completely different communities of interest, just like the Supreme Court informed in LULAC. Completely different high-rise buildings, higher education rates, low crime, low parking concerns along the Gold Coast, right? Extreme wealth on one side, and then on another side, a residential neighborhood.
What is a community of interest? Because you just mentioned a remediation going on in a particular neighborhood, which is time limited. Potentially, it may take years, but at some point it will presumably be completed. How can we possibly have a definition of communities of interest in a complex society where people have common interests with others in one or two aspects of their lives, but not common interests in other things? Are we supposed to assess what the current issues are in a particular area in order to determine whether there's an equal protection violation in a map?
Thank you for your question, Judge Patterson. I heard you earlier, and I'd like to come back to it because you're asking for the definition precisely. The New Jersey courts have long recognized communities of interest as a traditional redistricting criteria, and they've offered various definitions for them, although they're largely similar. You won't be surprised that they're largely similar. In Brady, the Supreme Court in 1992 acknowledged them as historical, social, economic, and ethnic realities, reflecting shared interests of communities. The next redistricting cycle, the New Jersey Appellate Division in Gonzales in 2012, referred to them as social, cultural, ethnic, and economic communities of interest. And more recently, Judge Karchman offers what I think is a helpful definition, which is similar to those that the courts, the two prior redistricting cycles offered. And this is in his Statement of Standards issued on January 7th, 2022, where he defines communities of interest for state legislative districting as, I'll read you the quote. It's neighborhoods, communities, or groups of people who share common values, goals, and concerns, such as cultural, ethnic, linguistic, economic, or religious interests, or shared infrastructure concerns, shared environmental concerns, or shared industry. So I read Judge Karchman's offering of that definition as consistent with what the New Jersey judiciary has offered the prior redistricting cycles, and also consistent with what's offered in other state courts and federal courts.
Is that a matter of geography? Does there have to be an assessment of what the primary interests and concerns of a particular area at any given time, which, as we all know, can change cycle to cycle and year to year and perhaps month to month? Does geography tell us what we need to know in this inquiry?
Geography is particularly helpful, which is also why compactness is directly related to communities of interest, right? Compactness is a question of geography. How close are the outer rims of that permissible circle to each other, right? So I do think that geography is a principal aspect for consideration here, taking into consideration that lower compactness scores are permissible if the purpose is to include communities of interest. Geography, Your Honor, has always been a part of how we've devised representative democracy in America. Right?
So-
It's always been.
But geography may not answer the question entirely. And what like speaking for myself, I'm grappling with is how could a court, looking at a map which has been developed in accordance with the statute, be able to say that this does not sufficiently join together people who have shared interests? The example you used is the remediation in Ward E. Am I correct about which
Yes.
ward you're talking about? Okay, Ward E is, you've just indicated, I have no reason to dispute it, has a major remediation important to the community going on. Are we supposed to look at the geography as based on which voters are potentially affected by that remediation? It seems like an unbelievably complicated inquiry that is being proposed here.
I don't think it needs to be that complicated, Your Honor. And I think that in the context of the case as is presented to the court, it's particularly respectfully clear. Actually, it's interesting because the map that was offered by the commission itself, which is found in the record at PA 63, offers an explanation. It names the neighborhoods associated with the new wards. Okay, so there's a grid, there's an index to explain what the new wards are. And I'll give you just an example for Ward F, it says Bergen/Lafayette. For the other wards, it says Downtown, Ward D is the Heights, Ward C, Journal Square, etc. So the commission itself defined these wards based on the communities and neighborhoods. And although for Ward F, it describes them as Bergen/Lafayette, in reality, if you look at the new Ward F, they removed Lafayette from it. So its own definition of the neighborhood and the community was sliced. I'm sorry, you're on mute, Your Honor.
But aren't we overreading with that? Isn't that the map is labeled so people can have some idea of what these are? I think that maybe.
Precisely. But that's precisely the point. And perhaps in another example, in another scenario, that we might devise a community of interest in a different way. But here, Your Honors, the communities of interest are a part of the wards and they're part of the neighborhoods. And they were simply sliced in half. And the same applies to what occurred in the area in between new Ward D and Ward E, right? Here, these neighborhoods are self-organized, they're self-realized, and there was no reason to change them. And we could have satisfied both population deviation and compactness. The only time the New Jersey Supreme Court, or even the courts at large, sacrificed compactness is because of the questions of political subdivisions that had to be respected. Here, there are no political subdivisions. The courts have always recognized compactness as a requirement, and there's no reason to sacrifice it here. We are talking about wards, not counties that are required by some constitutional, provision to be
The NJ
maintained in the process of state legislative districting.
Look to
Sorry.
the statute.
Go
We
ahead,
looked at
Justice
the
Patterson.
legislature's made a determination. I'm sorry, Justice Winter, after I'll be. We looked to the statute and none of that is spelled out here. None of the relationship between a community of interest and compactness, which you are articulating, has not been adopted by the legislature.
This is where it's endemic. It's a part, not endemic is not the right word. It is a part of the compactness inquiry. When the municipal ward law was passed in 1981, it was because of the earthquake that happened by the United Supreme Court's decision in Mobile v. Bolden in 1980. That earthquake occurred, 1980. That earthquake occurred because after passage of the Voting Rights Act 15 years prior, the reaction by Jim Crow cities was to move from ward-based districting to at-large districting so that local communities, in that case, Black communities, but local communities could not elect council people to effectuate their interests. And in 1980, the United States Supreme Court held that the Voting Rights Act could only be used as an enforcement vehicle if a smoking gun of discriminatory intent was found. And so this obviously threatened a huge amount of unrest with regard to the purpose of the Voting Rights Act. And the response by Congress in 1982 was to amend the Voting Rights Act to include an effects-based analysis. And this is actually very interesting and it's helpful for our purposes, because in 1982, they established 3 preconditions for establishing whether or not there's a voting rights violation. And the first one is geographically tied to communities. And in that respect, the communities that were focused on were racial communities. But that doesn't mean that the equal protection jurisprudence is only applicable to racial classifications for effective representation. That just simply cannot be the case. And so when the municipal ward law is introduced in 1981, and they say, we are introducing the municipal ward law in response to federal courts and federal jurisprudence grappling with questions about effective ward-based representation. What is a ward? A ward is a compact district within a municipality. It was responding, the New Jersey legislature was responding to the holding in Mobile v. Bolden to allow for ward-based effective community representation. And as my co-counsel, Ms. Steinhagen, pointed out, we should celebrate Professor Riox's contributions to the national jurisprudence as well as the state. He was invited to author the Musto Commission report, which informed the legislature. At that point, 20 years previously, he had created this extraordinary contribution, cited even by the United States Supreme Court with regard to the value of compactness, the standards to be applied to analyze compactness. And that was a part of the municipal ward law when it was introduced. There's an express requirement for compactness, a requirement that the commission here completely avoided and ignored. And in its briefing, it says, and this is pretty impressive, that they say that essentially that if you satisfy the population deviation requirement, you ipso facto satisfy the requirement of compactness. This essentially writes compactness out of the law, and it invalidates the entire purpose of the redistricting jurisprudence. One could imagine that if we were only focusing on population deviation, what would be the response by a savvy cartographer? If the only purpose was population deviation, you could draw a district that starts here, wiggles up here, goes down here, creates a fishhook and comes around. And so the counterbalance to that goal of population equality is compactness. They have to be read together. And a part of the compactness inquiry is understanding the communities that geographically comprise that compact district. And only when those geographic communities need to be a part, and for purposes of effective representation, may compactness be sacrificed and itself also offer a deviation different in order to include communities of shared interests. Because the whole idea is that you should be able to elect as a voter and as a resident, a legislator that will effectuate and represent your viewpoint. And
I'm
when,
sorry to
yes, Your
curtail
Honor.
sorry to curtail your answer, but I'm looking at the clock and I saw 2, potentially 3 additional questions. We need to wrap up your argument within the next 10 minutes. Others who had questions, do you still have them? If so, please go ahead, Justice Hoffman.
I do, Chief, but I'm happy to wait on it if somebody else does. I do. So,
Please go ahead.
Counsel, you mentioned before, and this is for follow-up to Justice Patterson's question about how you're not making a racial dilution claim, but in reality, in your complaint, in paragraphs 100 to 106, when you're discussing the fact that Jersey City tried to maintain a certain degree of racial demographic equity by taking into consideration, you called that effort illegitimate, illegal, arbitrary, capricious, failing to serve any legitimate redistricting goal, and violating law and public policy. But that community of interest falls within the definition of communities of interest that you provided before when you were defining communities of interest in answering Justice Patterson's question. And I'm not entirely sure how you reconcile those two.
Thank you, Your Honor. I did want to get to this point, so thank you for your question. When race is used as a predominant factor for redistricting, as the commission apparently claims was done here, it is required to apply strict scrutiny to its analysis. And the state must offer a compelling state interest that it was necessary to devise its action the way it did here. And here, this is also a bit of an admission from the commission that yes, they wanted to satisfy population deviation, which population equality, which we all know is a necessary requirement, but that it did so with specific focus on racial demographics. And therefore, because it was a race-based consideration as a predominant factor, heightened scrutiny must apply here. And I will call your attention also to PA 55, which is the commission's report where it details the racial changes of the demographics between the maps from 2012 to 2022. If you were to add up these rows for Ward F, for example, I'll give you just as an example. For Ward F for Ward A in 2012, if you were to add up the percentage that they say was white, the percentage of Hispanic, Black, Asian, etc., it does not add up to 100%. And that actually consists, there's only of these 1, 2, 3, 4, 5, 6, of these 12 rows, because 6 districts over time between 2 maps, only 2 add up to 100. This is not narrowly tailored. There's no compelling state interest here. Race-based, yes, you can have.
Did you bring a claim for race discrimination under the federal constitution or the Voting Rights Act?
No, we did not. The claim here is equal protection claim and violation of the municipal ward law.
But not on the basis of race. Right now, you're talking about how any kind of race-based discrimination requires the application of strict scrutiny, which I agree with you. I'm just confused because I searched your complaint and I didn't see any claim for race discrimination or racial gerrymandering, either in violation of the Constitution or the Voting Rights Act or the state constitution.
Thank you. Yes, this is not a race-based consideration. However, in the papers the justification offered by the commission was that this was to satisfy racial demographics. Why do we need to rely on the papers? Because there's a limited record here because of the lack of openness and transparency in the process. And this court has historically offered in Worden that heightened scrutiny is to be applied where the fundamental right to vote is violated, and not only the fundamental right to vote, but as Worden describes it, the equal right to vote. That was in Worden in 1972. And what I would also like to call your attention to is the separate, let me just pull it up for a moment, concurrence that was offered in Worden by Chief Justice Weintraub, who had been grappling with all of this redistricting jurisprudence during the time, right? Although there was only because counties were required as a political subdivision, which is not applicable here. But in his concurrence to Worden, Chief Justice Weintraub says that everyone has a political interest where he resides. He says, I agree with the result, but I would rest on a broader base. Here, the subject is voting. Basic is the thought that a citizen is entitled to vote to further his political interests as he sees them. Everyone has a political interest where he resides. And as we know, Worden was not a race-based challenge to the fundamental right to vote. It was a challenge to unequal treatment of the vote. And the court has, and I would urge your honors, as you consider the analysis here, to remember that New Jersey maintains a rich jurisprudential commitment to liberal construction of election law. That's in the absentee ballot case by the App Division in 2000. And the court has gone on and on with regard to the heightened scrutiny to be applied. Here, Ward F, as described in the commission report, which is in the record, is 37 points. It takes 37 points to describe the geographic changes and the composition of new Ward F. This is reminiscent of the district that was found to be an uncouth 28-sided figure in Gamillion by the United Supreme Court, even before the court acknowledged that gerrymandering claims are even justiciable. This is the equivalent.
Ms. Bromberg, I'm afraid we're running out of time. Let me ask if any other justices have questions. Anything you'd like to add in no more than 2 minutes to sum up your argument?
Yes, Your Honor. I would simply like to reiterate that the equal protection jurisprudence and equal treatment under the law, including as it relates to the fundamental right to vote, the fundamental right to equal vote, and effective representation, is what informs the process of fair and effective representation, which is effectuated through the redistricting process. It was these principles that animated the municipal ward law passage that should be read consistent and congruent with the municipal ward law. And we would urge your honors to find that to reverse the conclusion reached by the appellate division that there was no equal protection violation, even when the map is significantly non-compact and when numerous communities of interest are divided. We believe that here the map was irrational, but for future litigants, there should be a standard that is offered, and the principles of compactness at a minimum, including the relationship of communities of interest vis-a-vis compactness, should offer guidance for future jurists and litigants to analyze the constitutional and statutory precepts set out by the municipal ward law. We would urge the court to reaffirm the application of heightened scrutiny and the value of the traditional redistricting criterias. For future jurists, we would appreciate it that discovery is offered. Here in this case, all the wonderful questions that arose are only because we were able to bolster a verified complaint. But for future litigants, they should be offered the ability for discovery. We would urge that the commission's map is found to be irrational because it did not offer explanation for its limited population deviation, and it ignored the traditional redistricting criteria of compactness and communities of interest in violation of the municipal ward law and the constitutional right to equal protection. And we ask your honors to remand the matter to the lower court. This is the final point, to assign a special master to draw a new map with the commission immediately, sufficiently ahead of the petition deadline so that candidates have notice and opportunity to collect the requisite signatures. I want to thank your honors for your nice questions this afternoon. It's my first time appearing before you all, and it's been an honor.
Thank you, Ms. Bromberg. Mr. Calderon, you're up next, and I'm going to invite you, as we do routinely, to feel free to incorporate some of the arguments that your fellow counsel have made, and in doing so, curtail the presentation that you had in mind. Please go ahead.
Thank you, Your Honor. Good afternoon. I would like to retain 1 minute for rebuttal. May it please the court, I will present my complaint anew, citing case law and highlighting facts uncovered during this legal process that allows this court to affirm that the defendants have violated the municipal ward law of New Jersey. My complaint, in lieu of prerogative writ, has the objective for the court to oversee the Jersey City Ward Commission, a commission of the city, in drawing a ward map that obliges to the municipal ward law. I will begin with the fact that a complaint in lieu of prerogative writ must show that the governing body has performed their duties in a capricious, unreasonable, and arbitrary manner. The minutes of the Jersey City Ward Commission meetings on PA 224 through 232 of my appellate division appendix shows that the creation of the maps was never discussed during the Ward Commission's public meetings. The Falco Instant Towing, Inc. versus Borough of New Providence states clearly, and I quote, "Any vote conducted on business not substantiated by the minutes of said public body's meeting is capricious, unreasonable, and arbitrary." Second, on the merits, the 2022 Jersey City Ward Map, Exhibit F, PA 24, my certification, as presented in the report of the Ward Commission, PA 14 through PA 25, shows the illegality of the map and the violation of the law by the commission. The map on PA 24 shows Ward F being cut off from the east side by Ward A, which encompasses Ward F along the eastern border and cuts Ward F from the waterfront, which includes Liberty State Park. With this drawing, Ward F ends up looking like an L or boomerang, as noted by Judge Tarula in the oral opinion submitted in Exhibit C, page 18, line 20 to 22. Judge Tarula says, and I quote, "A ward can be shaped as a horseshoe or an L, as it is here. Ward F looks like an L, maybe a boomerang, but something with a bend," end quote. In Jackman v. Bodine, this court, the Supreme Court, states it clearly, and I quote, "Horseshoe-shaped and L-shaped districts are not acceptable." So Judge Tarula's testimony on the record of the Superior Court's opinion goes to the heart of the violation of the law committed by the Jersey City Ward Commissioners. Districts, according to this court, cannot be shaped as horseshoes, as Ward A is, or an L, as Ward F is. And violating the municipal ward law violates my constitutional rights are also violated, which leads to a violation of the Equal Protection Clause. I have been asked a few times, why is this case important to you? I was taught early in my education, as I attended Chancellor Avenue School in Irvington during the late 1980s, that injustice had to be faced and addressed. In my upbringing, I was taught to think of the greater good, supported with stories of American leaders that fought injustice during very violent times. I was taught what aggression against the poor and people of color was, so I can recognize it as an adult. Discrimination and racism are hard to prove, but there's no doubt that the actions of the Ward Commission had racial biases and aggression towards the people of Jersey City. Ward F saw 1 in every 3 Hispanics diluted from the war, as our parkfront neighborhood is now desirable. I will leave your honors with a quote by Mary McLeod Bethune that truly gives the reason to the matter of this case. I quote, "We are anxious for you to know that we want to be and insist upon being considered a part of our American democracy, not something apart from it. She passed away in 1955, and it is a shame that in 2025, we are still asking to be considered a part of American democracy. I will attend to your justice's questions. Thank you for your time.
Questions, anyone? Mr. Calderon, no questions from members of the court. Is there anything else you'd like to add?
The only thing I will tell the court and your honors is it's your opportunity to let the translation of this important statute that will affect future generations. This court has the opportunity to correct the unlawful actions of the Jersey City Ward Commission and the named commissioners. Thank you.
Thank you, and thank you for your concise presentation. Mr. Slocum.
Thank you, Chief Justice, and please the court. On behalf of the ACLU of New Jersey, I have 2 points to make, and I can make them quite succinctly. First, Chief, during the earlier oral argument session, you were asking how the legislative history fits into the statute and whether communities of interest are really properly included based upon the history. I'd like to pick up on where that was left off. I believe, Chief, you were quoting from what is Roman numeral 6 of the Musto report. It is reproduced at page 13 of our appendix. Your Honor, you were quoting, looks like one sentence. The report is, of course, a much longer document. At page 14 of our appendix, the document continues. So Roman numeral 6 is sort of the introductory summary of what follows, and what follows in many tens of pages thereafter is the real report. And page 57 of the report is where the Musto Commission, and again, this is page 14 of our appendix. It's page 57 of the Musto report, page 14 of our appendix. That's where they're explaining what they were envisioning by the 6th recommendation, the one that was adopted into the municipal ward law. And there are 2 sentences which I believe are really germane to this conversation we're having. Quote, the use of wards for representative purposes can serve a legitimate public purpose, particularly when a municipality includes diverse groups of residents, end quote. It then continues, quote, wards generally are not authorized by the legislature for very small communities, the assumptions being that the rationale in favor of wards becomes weaker in smaller municipalities, and that wards would fragment the community unnecessarily, end quote. And so I believe with the legislative history, which of course the whole report was adopted by the legislature for recommendation 6, not just the introductory Roman numeral, but page 57 as well, as the governor's signing statement also makes clear. They're talking about communities within inside the municipality, groups of residents, and making sure that those groups receive appropriate representation when you decide what the districts are going to look like. And so we therefore respectfully submit that concepts, traditional redistricting concepts like communities of interest are to be considered. It's right inside the legislative history. And if in fact a ward commission disregards and does not even consider communities of interest and what the groups of residents look like, that's a problem under the statute. That's our first point we'd like to make. And the second one goes to some question that you, Justice Wiener, after were pointing out about Davenport. And Your Honor was correctly pointing out that under the Davenport line of cases, compactness is of a limited utility when you're dealing with the constitutional concepts and you're dealing with New Jersey, which has an odd shape to begin with. They're not one of those big squares from out west. We're kind of this weird peanut or lima bean, and all of the municipalities are odd little amoeba shaped. So necessarily, when you're dealing with equal protection issues and population equality must come first, compactness, when you're respecting political boundaries, needs to come second, and it's a much reduced factor. But here, we're not dealing with that particular context. We don't need to preserve and protect political boundaries. Within inside an individual municipality, we're dividing things along groups of residents in a way that makes sense. And that's what the compactness inquiry really looks to. And the word compactness, no matter how you slice it, it really talks about shape. Shape can be expressed in math and statistics. There are established tests, some of them already exist, some might come up in the future, to analyze what things look like and how do you analyze it mathematically and statistically. We respectfully submit that in these sorts of cases, math and statistics can and should be considered, and that the appellate division erred when it arbitrarily said that math And these tests, you can't even consider them. So that is our position. We have, I'm happy to answer any questions you might have.
Any questions? Mr.
I-
Slocum, anything you'd like?
I'm so sorry, Chief. I had one.
Go ahead.
I thought that I saw in your brief a reference to the nationally accepted definition of compact, and I was hoping that you could share that definition with us.
Yeah, so Ms. Bromberg set forth a rather comprehensive, definition based upon the case law. I don't think it's necessary to repeat it, but I would point out that inside this complaint, they set forth what is and is not compact. We are at the pleading stage, and so I believe it's important to emphasize that at the pleading stage, the plaintiffs have alleged on a motion to dismiss that it is not compact. It's supported by math and based upon the communities of interest, and therefore the complaint should survive past the pleading stage. If that answers your honest question.
Mr. Slocum, we still need a definition. That doesn't, that obviously the motion to dismiss standard is relevant, but it doesn't assist the court in determining the issue on its merits that we have before us.
Yes.
So
no,
are you deferring to Ms. Bromberg's definition?
No, I'm happy to clarify that, Justice Patterson. The definition of compactness, I don't think that this court needs to or necessarily should adopt a specific bright line percentage below or above a certain mathematical exactitude. You don't need to do that. This is an issue for the experts to deal with and the witnesses to deal with at the trial court level.
But substantively, what would you characterize as the meaning of the term compact for purposes of this statute?
Of course, for purposes of this statute, what the Municipal Ward Commission should do is consider the various communities of interest and pick a shape that honors those the best way, the most rational way that you can to come to a shape of all the various wards that makes the most sense and is not, these wild, irrational shapes. They should have presumptively lower scores. Maybe they can have, they can have different scores based upon the particular facts at issue. But it's really, you know it when you see it, and it's based upon expert testimony. If I'm answering your honest question.
Counselor, going back to sort of one of the arguments that was made in this case, there's a discussion on affordable housing issues, and there's then sort of allegation that a certain group who was really strongly in favor of affordable housing was broken apart and was cracked, right? I think that's the phraseology that's used, and therefore limited their imprimatur and their influence. And there's a discussion about 15,000 people. 15,000 move out, who may have then had one perspective on affordable housing, and 15,000 were moved in, who may have had another perspective on affordable housing. Assuming that other 15,000, that second 15,000 did have another perspective, and they were a community of interest, and their community of interest was, we don't want any more affordable housing than is absolutely legally required. We want the absolute bare minimum under the law. If they had brought a claim and they had said our community of interest was broken apart, would you be taking the same position and defending them?
The position we're taking, Justice, is really with respect to the appellate division's opinion, which says that communities of interest is not a proper consideration. We take issue with that. Does that answer your question?
But to the degree to which there is a recognized community of interest that had the exact opposite perspective on affordable housing, presumably then you would also be defending their right to be kept together as a community of interest and the imprimatur that their amalgamated power would have, right?
Yeah, I think I understand your question, that on remand, if in fact it is the case that, the plaintiff's versions of what the communities are is X, and the defendants say why you're wrong, and there's a disagreement. So to your point about the 1,500 people, maybe they are their own community, which was respected, then there wouldn't be an issue. If I'm answering your honest question.
Yeah, I think we're missing each other, so I'm gonna try one more time. if that 15,000 that was moved in to replace the 15,000 when was moved out, presumably had a different perspective and was, let's say they were not in favor of affordable housing, would they have the same claim to say this redistricting, it negatively impacted our community of interest, therefore it was not appropriate? You should not have broken apart. You should not have cracked a community of interest that was against affordable housing. Would they have that same claim?
Yes. So if 15,000 other people were their own community and they felt that they were aggrieved because they were divided in an improper way, in a non-compact way, in violation of municipal ward law, then yes.
And would you, is it the responsibility of the commission to try to identify those communities of interest before engaging in the process of figuring out the ward map within the time periods that are given? And if so, how is the commission supposed to go about in identifying all of the different communities of interest that could potentially be impacted by trying to achieve population equity, which we all know is the paramount goal?
Of course. So yes, they need to do their best to identify the various communities within the municipality before they draw up their lines. And to your question about how are they to do that practically, well, yes, it is a shortened period of time, and they need to do their best. And if they can demonstrate on the remand hearing under the standards that the court sets forward that, you know what, we did our best, here are the communities as we understand them, we tried really hard to honor them in this way while making compact communities, and they can express that in the appropriate way according to whatever standard the court sets forward, maybe that's an appropriate way for them to achieve the objectives of the statute. Our point is merely that under the municipal ward law and on the motion to dismiss standard, the plaintiff has set forth allegations that it is not compact and that communities of interest were disregarded improperly. And all we're saying is this standard, the appellate division was wrong in their instructions in saying that math can't be considered and communities of interest can't be considered.
Let me ask you a very basic question. Is it the obligation of the commission to try to identify which potential voters feel a particular way about an issue that may be an important issue in Jersey City now? It may fade away by next year. A lot can happen in politics in a short time. It seems that the communities of interest concept is being presented as gauging the views in part, because geography, obviously, everyone I think so far who's spoken so far has agreed, but to some extent gauging the views on the merits of local issues or maybe broader political issues as the community of interest votes a particular way on or would vote on a particular way on a particular issue and therefore must be kept together. Am I right that that is part of this concept of communities of interest?
What the community looks like is absolutely part of the analysis. So, you know, in terms of what the community looks like, is geography for sure.
You're not saying looks like physically, or are you?
Looks like in the broadest possible sense.
So the commission has to look at a community demographically, but also on their opinions on various issues.
I'm not sure about opinions on issues.
Well, affordable housing was the example that Justice Hoffman just raised. There was earlier a discussion about remediation, and in one ward, remediation being an ongoing and obviously potentially politically controversial issue. There seems to be a concept floating here that I wonder how practical it is that people who have a particular view on a particular subject then might comprise a community of interest that has to be a consideration in drawing a map. There may be a general sense if one lives in a community of how many people feel this way or many people feel that way, but everybody's got their own opinions. What has to be done? Does there have to be a poll of the local community to find out if they're for or against a particular issue?
I don't believe there needs to be a poll, Justice. No, in terms of what the community looks like, again, in its broadest possible sense, there needs to be some sort of understanding. The plaintiff has their views as to what are the communities of interest. They've alleged in their complaint, they're on a motion to dismiss standard. Maybe they can prove it, maybe they can't. That's not our
But
point.
but I think at a more fundamental level, we need to know what this is. And is it true that part of the task that would be the commission's task in defining a community of interest is what are their views? And I'm being very global because people individually have all kinds of nuanced views on different issues, but do they all agree on something, or do most of them agree on a political issue that may be very hot right now in Jersey City?
Yeah,
And
maybe
that's,
I could-
am I missing something, or is that concept part of this? Because it sounds like it is.
It can be part of it. If in fact it is the case inside a particular municipality, put aside Jersey City for a moment, that everyone in this particular few blocks, they feel really strongly on this issue, and that's a known concept. Why can't that be considered?
And how is that proven? Are assumptions made that because people are of a particular demographic category or they live in a particular place that they feel a particular way about a local issue?
That'll be for the plaintiff to plead what they believe the communities of interest are. Our point is merely that it's an appropriate thing to consider. The Musto Commission said that groups of residents should be grouped together. You need to consider what the community looks like. And our only point is that the communities of interest is a proper consideration of the statute.
Other questions, anyone?
I just one
Just
more.
quickly, Chief.
Go ahead.
Counsel, your colleague made the same point that we should look to outside jurisdictions that have engaged with this, a community of interest definition and the standard. But in some of those states, there's actually statutory language or even within the constitutions in those states that support communities of interest and support that language. Is there anything like that in New Jersey that you can point to that we should be relying on to define communities of interest under the standards that the plaintiffs are pointing out?
Are you talking about a statute that defines community of interests? No. I think
What's our authority then?
I believe it's the legislative history. It's at page 14 of our appendix. It's page 57 of the Musto report, which talks about the goals of the municipal ward law is to make sure that diverse groups of residents are appropriately combined together into wards, and that you don't want to divide communities unnecessarily.
Well, that part about dividing communities unnecessarily is talking about not having wards in smaller municipalities. There's no reason to have in very small communities that it would create, they would be weaker by having wards fragment those communities. So that's not really talking about communities of interest there.
I respectfully disagree, Justice. They're talking about what the community is and what the groups of the residents are. By definition, if you're a very small community, odds are you are more aligned, just by sheer statistics, than a very, very large city.
Council, claims have been made before. I think Milligan might be one of them, in which communities are not cracked, but they're packed, right? They're packed together. They're kept together for the purpose of just keeping them in one area and nominalizing their political imprimatur. What would your perspective be if the evidence in this case came out that the communities of interest were intentionally being kept in one ward so as to nominalize their political imprimatur?
If that were something that the Municipal Ward Commission here were doing, that would of course be a problem with the statute.
By keeping the community of interest together?
I'm sorry, you said, could you rephrase the question, Justice? Perhaps I misunderstood it.
Yeah, if there have been claims before that have been made that in the redistricting context, communities of interest are actually packed together. That's the phrase they use. So that they just keep those community of interest in one area, one distinct area, so as to nominalize their political imprimatur. If that was happening here, if there's evidence that had happened here, that New Jersey City had attempted to keep the community of interest together, because in their perspective, that actually would stop sort of the spread of ideas that they felt were anathema. What would your perspective be on that? An effort to keep communities of interest together because there was a sense that that may actually delegitimize their political power and not legitimize their political power.
Respectfully, I don't believe I have an answer to that question, Justice. while we're focusing on the allegations of complaint that communities were improperly divided, and our position is under the appellate division opinion, they were wrong to say you can't consider that.
Mr. Slocum, anything you have to add?
No, thank you for your time.
Thank you. Mr. Orlando.
Yes, thank you, Chief Justice Radner, and may it please the court. There's a lot to address from what's already been said, but let me just start by saying the meaning of compactness in the districting context was well settled by this court when the legislature adopted the municipal ward law in 1981. In 1966, the state constitution was amended following what we've discussed it already, Reynolds v. Sims, striking down our prior system, which was based on the county, one senator for each county, and assembly people apportioned based on county population, similar to our federal system in Congress. That was struck down in Reynolds v. Sims in 1964. This court in Jackman v. Bodine 1, actually took an incredible step and said, no more elections until we fix this problem, and ordered that the Constitution be amended. The Constitution was amended. What the Constitution was amended to require for assembly legislative districts was that they be contiguous, they be compact, and there be a limit of population deviation. Those are the same three criteria that the legislature adopted 15 years later in the municipal ward law. The same three criteria. Following the amendment of the Constitution, that set off a series of cases where in in less than a decade, there was at least 10 cases before this court interpreting exactly what this new criteria meant and how it interacted with the requirements of the United States Supreme Court of one person, one vote, how that was to be applied and what these things made. In those cases, this court consistently held that population equality was the paramount consideration in districting. The compactness was only a material factor if a map contained, quote, bizarre designs, unquote, such as shoelaces or horseshoes, and that compactness is an elusive concept of limited utility because of the odd configurations of our states and its municipalities. It also said that compactness was a much reduced factor when the map was based on pre-existing political boundaries. And I know there's been statements here that the map was not, that there was no pre-existing political boundaries, but in fact, the map for Jersey City Ward Commission produced was based on pre-existing political boundaries within the municipal context, and that being election districts, as the plaintiffs acknowledged in their complaint, and provided a map which can be found at PA 89, I believe it is, showing that. So it was based on the election districts where the building blocks of which the rest of the map was built. So they were pre-existing political boundaries. So compactness was defined. It was addressed by this court. This court grappled with it in great detail. And at every instance it said, look, population equality has to be paramount. That was said in Jackman versus Bodine 5, and it was reaffirmed in Davenport 2 by this court. So in 1981, then, the legislature passes municipal ward law, and it adopts the same exact criteria. In so doing, it did not include communities of interest. Communities of interest was a well-known redistricting concept at the time of the adoption of the ward map. In fact, a lot of the cases that were before this court, Jackman, Davenport, Scrimminger, all involved the idea of preserving communities of interest. At that time, the community of interest was defined as being the county. The county had been the traditional districting building block of our state, and that was people that were resistant to population equality, being as equal as possible, were arguing, hey, we need to have in place, we need to preserve counties. In fact, the state constitution requires that counties be preserved in election districts. And of course, that was struck down by Scrimminger, saying that our own state constitution was unconstitutional because it violated the equal protection clause of one person, one vote, that counties couldn't be preserved. So this idea of protecting communities of interest was found to be, in Jackman, said to be wholly irrelevant. And that was when we could actually define a community of interest based upon a political boundary, being a county or a municipality. Here, as I think a lot of the questioning over the last couple of hours has indicated, is that within the municipal context, trying to define a community of interest, particularly where in a case where here, there's no allegations of racial discrimination, there's no VRA claims. It's based upon, as Justice Patterson has been, I think, pushing on, it's based upon, and Justice Hoffman too, based upon concepts as, people's political beliefs, which I believe was Justice Patterson that said, people can agree on certain issues. They can agree on remediation. They can agree on affordable housing, but they might disagree on other issues important in municipalities, such as, active recreation space versus passive recreation space. So defining that community of interest is incredibly difficult, and it was specifically rejected by this court in the concept of legislative redistricting, involving a much more objective form, being the county in Jackman and in Scrimminger, as being not able to be preserved over the population equality.
Council, you mentioned that in Jackman, the definition of compactness was something that is not a bizarre design, such as a shoelace or a horseshoe. But here, didn't the trial court find specifically that Ward F is bizarrely shaped because it looks like an L, maybe a boomerang, something with a bend in it, and that Ward A looks like a horseshoe as it wraps along the east side of Ward F extensively, and Ward B on its west side?
I believe the trial court may have said those words. I don't know if they used the word bizarrely. I think they said there was nothing impermissible about being shaped like an L of Ward F. And again, DA011 is a map of the current, is a production of the current map. I would submit that they're not bizarrely shaped, that they're not, and especially.
But the trial court did specifically say that Ward A, quote, looks like a horseshoe as it wraps along the east side of Ward F extensively, and Ward B on its west side, correct?
I don't have the quote in front of me, but I will take your Honor's word for it. If that's what they said, that's what they said. But again, I would note that it only becomes irrelevant in evaluating in Davenport and Jackman. They said it only becomes a relevant factor when it is a bizarrely shaped district. That doesn't mean that it can't be and that it's not compact. It's also a reduced factor when you're talking about population equality, which again, we had a map here that was 59%. Jersey City had an unconstitutional ward scheme following from 2000.
Understood. And you say that population equality is the most important factor and that compactness is not relevant unless there's a population equality problem. But the municipal ward law could have been written to say that population equality is the most important factor and that compactness is not relevant unless there's a population equality problem. And it wasn't. Instead, it was specifically written to require that the wards be compact. So don't we have to respect that legislative choice that they chose to require that the wards be compact and not chose to require population equality as the only factor, or sorry, as the only requirement?
Well, it's not the only requirement. And it was written, it could have been said population equality had to be, was the only factor, and it wasn't. But I mean, you have to also bear in mind that that statute was written with the understanding at 1968, Reynolds v. Sims was applied to municipalities in Avery versus Midland County. So the same concept of population equality was set forth by this U.S. Supreme Court. And of course, federal law, as this court said in McNeil, federal districting law applies to the states. So the 14th Amendment requires population equality for municipalities in districting. And that was required here. Plus, this Supreme Court, in interpreting compactness, had said in Jackman and in Davenport too, that population equality had to be paramount. So again,
I
that's
understand,
holding
and
the
therefore the
Supreme Court.
municipal ward law could have been written without even referencing population equality, and it would have been required nonetheless. But my point is, it is written to say the ward commissioners shall fix and determine the ward boundaries so that each ward is formed of compact and contiguous territory. That is not an independent constitutional requirement. So if the legislature did not think that the wards had to be compact, it would not have had to write it that way. But instead, it specifically wrote, the ward commissioner shall fix and determine the ward boundaries so that each ward is formed of compact and contiguous territory. Don't we have to respect that choice to require it to be of compact territory?
Yes, and I would submit that this map is compact.
Thank you.
Counselor, when you say, I would submit that this map is compact,
Yes.
it doesn't strike you that the statistical analyses of these maps and the wards, even relative to what they were 10 years ago, seem to be dramatically and materially different? I mean, when you sort of say, I think it's compact, we do have statistical analysis that would say it doesn't seem compact and seems far less compact than it was. Well, with that in mind, what makes it compact?
Well, first, with the statistical analysis, we have plaintiff's representation of what the statistical analysis is. So that's the first thing. Second thing, I would say, as I think Chief Justice Rabner inquired, Ernest Rioch, Professor Rioch, published his article in 1961 where he set forth his standard. This court has been grappling with compactness since the amendment of the state constitution to require it for legislative districts. And at no point in time in Davenport 2, in Jackman 5, when compactness was specifically addressed, was Rioch's test said to be some sort of determinative of what compactness was. And I think, as was pointed out during the discussions, as long as you're above 0.1 on those tests, you're compact. It's just a variation of degree. So this map is compact. Even if you use plaintiff's own calculations, it is compact. It might not be
Sorry, where do we find that?
Could be.
Where do we find that like 0.1 is a cutoff, and as long as you're above 0.1, you're compact?
I believe that's on the Princeton Gerrymandering's website. We cite to it in our appellate division brief. It is in there, and that's what they say on there. Princeton Gerrymandering Project's website. As long as it's above 0, it's compact. It's just a question of the degree of compactness according to these constructs. And I would just note too.
As long as it's above, sorry, first I thought you said as long as it was above 0.1, then I thought you said as long as it's above 0. So what specifically does the Princeton Gerrymandering Project say?
I could, if you give me a second, I could find out what our site to it was in our brief. But I believe it's as long as it's above 0.1.
Okay, I can, if you're just referring to what was in your brief, I can check it myself. Thank you.
Yes, and I believe it's on their website too, because I think we cited in our brief to their website. They talk about compactness.
Mr. Orlando, the Aptiv remanded for a limited fact-finding proceeding. Do you agree with the direction given by the Aptiv? And if so, what should be happening on remand? And if not, why?
I guess the short answer is no, I don't agree that there should be a remand. I think that this court should affirm the map, should affirm the trial court's dismissal of the complaints with prejudice, and that the map should be allowed to proceed. I believe at the end of the month, petitions are being issued by the clerk for the upcoming municipal ward or the upcoming municipal elections. Mayoral candidates have already selected running mates based upon what the map looks like currently. So I think that the appellate division in having a remand, no matter how limited, I don't think that was called for in this situation.
Sorry, so as Justice Pishrali just pointed out, the appellate division did reverse the dismissal of the plaintiff's claim as to the municipal ward law and remand for limited fact finding. Did you petition for certification challenging that portion of the appellate division's judgment? So saying there should be no remand, the map is good as is. I'm petitioning for certification so that the MWL claim is dismissed, not so that the dismissal of that claim is reversed, as the appellate division did.
No, we did not petition for cert.
And did you oppose the remand in your briefing?
In the briefing
To us.
to us, I don't believe that no, not in the opposition to the certifications. To the petitions for certifications, we did talk about it and discuss and express our opinion that I just expressed now in our oppositions to the amici's when they were calling for a larger hearing. We said, hey, we don't even need a hearing. Again, the appellate division.
But it would enlarge the judgment in your favor in that the appellate division specifically did reverse the dismissal of plaintiff's municipal ward law claim and remand it for limited fact finding. And you're saying that the appellate division's reversal of that claim was wrong and that it should be dismissed. That would enlarge the judgment in your favor, no?
Yes, it would.
Okay.
The appellate division applied a rational basis test and asked whether there was a rational basis for the commission's decision. What's the basis for that approach? What supports that principle?
I'm not sure, Your Honor. That's the same question that I had. I think that Your Honor's approach, our Chief Justice's approach in the 2022 congressional redistricting should be the standard here. Again, that's the same thing that was set forth in Davenport, great deference to maps unless there's a positive showing of invidious discrimination. Here, there's not even an allegation of invidious discrimination, much less a positive showing. As such, I think there's no reason to revisit this map. There's no reason for the remand.
Perhaps Ms. Steinhagen on rebuttal can comment on the standard.
For a rational basis.
Yes.
I would just get back because we were talking before about the statistical analysis. There's no indication in any of it that it would apply in a municipality like Jersey City that does have oddly shaped boundaries, as the appellate division acknowledged and as any cursory look at the shape of the city would acknowledge. The city is defined by bays, by rivers, by inlets, by the Palisades, and by ancient boundaries of surrounding municipalities. It's not a perfectly shaped municipality to begin with. So in terms of drawing the map, that all has to be taken into account. And that's one of the issues with compactness. And Professor Rioch himself acknowledges that those factors could influence the amount of compactness that would have itself in applying his statistical analysis. So again, Jersey City had an explosive growth in population, particularly along the waterfront. You had Ward E having 21,000 more residents than the next most populated ward, 21,000. And I believe it was 29,000 more than the least populated ward, which was Ward D. So something had to be done. Ward E had to be shrunken, both geographically and population-wise, and people had to be put into surrounding wards, and that's what happened. And there was no invidious discrimination here. There was no basis for any sort of civil rights action claim. There was no basis for an equal protection claim. What the Ward Commission did, and again, this Ward Commission is composed of the County Board of Elections. These are individuals who, it's a bipartisan board. They're commissioned by the governor. They serve 2-year terms. They oversee our elections. They count ballots. They oversee poll workers. They, handle voter registrations. They secure voting machines. They administer our elections, and calling into question their integrity, saying that they're retaliating against specific council person in Jersey City for merely redrawing a map that they were required by statute to do and by the federal constitution to do because of the amount of out of whack, I use that phrase, that it had become in terms of the population deviation amongst the wards. They redrew the map and they reduced the population deviation to 1.8%. And in so doing, they, protected election districts. They used the election districts as the building block. People weren't moved out of different polling places, which we know from other municipalities. In Newark a couple of years ago, it happened when people's polling place was changed. It caused mass voter confusion on election day. And they also, in so doing, did not dramatically alter the demographic makeups of the existing wards. So all of that indicates that this map was that there's no basis for a challenge to this map. Also, this Board of Elections, they didn't just redistrict Jersey City, they redistricted other municipalities in Hudson County. If you're talking about having a procedure where you have a complaint, you have discovery, you have depositions, you have expert testimony, this is going to be a process that takes time. And these individuals also did this in other municipalities. And if you lessen the standard from the standard set forth or reaffirmed by the Chief Justice in the 2022 and by this court in the 2022 In re congressional districting case, you run the risk of being bogged down in litigation going on for years over the redrawing of ward lines. Even if this was remanded to a special master, if the definition, if the standards of judicial review are changed, if this is remanded to a special master, who's to say that somebody else can't just baldly say, as plaintiffs have done here, it's not compact. We don't like the shapes. Communities of interest are dispersed without even being able to define what those communities of interest are. We're just saying the community of interest are dispersed.
Sorry,
I'm not happy with
I
this.
just ask a clarifying question? I'm sorry. I thought that pursuant to the law, the commission consists of members of the County Board of Elections of the county in which the municipality is located, along with the municipal clerk. You seem
Correct.
to be saying that the commission is the same in every municipality. Is
Well,
that
the Board of Election members are.
okay? So
clerk
there's
changes
just one
briefly.
different member in each different municipality, and that's that individual municipal clerk.
Correct.
Okay, I understand. And how many commission members are there? Can you remind me?
There in Hudson County, there were 7 for the Jersey City Ward Commission. Hudson County has 6 Board of Election members, 3 Republicans, 3 Democrats,
Thank you.
2-year terms.
Council, we all agree that compactness is a requirement. So what would plaintiffs have to show to satisfy a motion to dismiss on the issue of compactness? What would they have to prove?
Plaintiffs would have to show to overcome a motion to dismiss for compactness.
What would plaintiffs have to show that the compactness requirement has not been satisfied?
I believe that they would need to show that there was that the district was irregularly shaped, that it was shaped like I could imagine if for Jersey City, if you had it down one part of it like a dumbbell, right? One here goes through there. I would assume that would maybe be a district that would be required to be looked at if there was also a showing of invidious discrimination or some sort of allegation along the line that the drawing of the district in such an irregular shape was for an impermissible purpose, such as invidious discrimination, which obviously there's no allegation of that here. Or if that the
So you're saying that the requirement in the statute that the ward be drawn to be compact only goes into effect if there's an allegation of invidious discrimination?
Your Honor, what I'm saying is that it's the same definition, the same standard that this court set forth in Davenport 2 when it comes to judicial review and reaffirmed just in 2022. Again, our Constitution requires compactness for legislative districts. And I would direct you to, I believe it's DA 007. We provided a map of the different legislative districts in the state. And you can look how they're shaped. I mean, and that again is a requirement of compactness in our Constitution. So again, the same test I think should apply in the municipal context that this court has applied to the legislative review of maps.
And that's a test based on visualizing the map and I know it when I see it to note the famous quote that Mr. Slocum referred to and decide what it looks like. Is it really just too far over the line of oddly shaped without any kind of mathematical interpretation?
It's never implied a mathematical interpretation before, even though the test existed. In Davenport 2, again, in Davenport 2, again, the court said the judicial role in reviewing the validity of such a plan, which is a plan in which there's no allegations of racial discrimination, is limited. Reapportionment is essentially a political and legislative process. The plan must be accorded a presumption of legality, with judicial intervention warranted only if some positive showing of invidious discrimination or other constitutional deficiency is made. The judiciary is not justified in striking down a plan otherwise valid because a, quote, better one, in its opinion, could be drawn. And again, this court reaffirmed Davenport just in 2022, saying in the context of congressional districting, which if you look at how those districts are drawn, we then provided a map of that in, I believe that's DA007. Or no, sorry, DA009.
So you're not
And
saying
reaffirmed that and said that exact quote, made that exact quote, and said it's not the court's task to decide whether one map is fair or better than another. So again, that's been the standard for review for legislative districts since Davenport was 74 or 50 years ago. The same three criteria apply to legislative districting that apply to municipal ward law. So I would submit that the same standard of review should apply, and intervention should be warranted under that same standard.
Counsel, are you saying there has to be an allegation of invidious discrimination or a positive showing of invidious discrimination to survive a motion to dismiss?
I believe that I'm not saying it. I believe this court has said there needs to be a positive showing.
But how can there be a positive showing if there's been no discovery case?
Well, there can be a positive showing by basically how the map is drawn. If the map is drawn in a way to disenfranchise a protected class of individuals, then that's how you would do it.
And why does it have to be a protected class?
Invidious discrimination is discrimination based upon an immutable characteristic. So you cannot have invidious discrimination against, for example, a Republican or a Democrat. Our court has consistently, beginning in Davenport, rejected that. And the United States Supreme Court in Ruchu in 2019 said there is no federal cause of action, justiciable cause of action for political gerrymandering. So it needs to be an immutable characteristic, which I guess it doesn't need to be a protected class necessarily, but it needs to be an immutable characteristic.
I think, can I just follow up on one point you made? On a motion to dismiss for failure to state a claim, ordinarily, of course, we accept the facts a complaint as being truthful. You're saying now that the consideration on such a motion when it comes to whether there's a violation of the law as to compactness, that the plaintiffs have to demonstrate there was an irregularly shaped map. What does a judge do? Just eyeball it on the motion and decide right then and there whether the shape is irregular, or is that something that should be resolved after and deny the motion in and of itself?
I think what I'm saying is what this court said in Davenport 2, and again in 2022 in the in-rate congressional districts, is that there needs to be a positive showing of invidious discrimination in order to get to that stage where you go into that sort of put the burden back on an apportionment committee to justify why it did what it did. And again, compactness is a requirement in our state constitution for legislative districts. So that's what this court has said since 1974 is the standard of review for of a map And so absent that, and in Ray Congressional District, a lot of the claims, equal protection violations are.
Sorry, I'm looking, counsel, at that quote from Davenport, and it specifically says the plan must be accorded a presumption of legality with judicial intervention warranted only if some positive showing of invidious discrimination or other constitutional deficiency is made. So why is compactness in this case not another statutory deficiency that plaintiffs could make or allege, because the statute specifically requires compactness?
I believe that the argument was the quote was constitutional deficiency.
Correct, but as you pointed out, compactness is a requirement in the Constitution as well. So compactness would have been a separate constitutional deficiency in theory under that language as well. And here, of course, it's not a constitutional argument, it's a statutory argument. But I don't see how Davenport, the decision in 1974, gets us to reading the word compact out of the municipal ward law, or to us holding that compactness is only relevant if there's a showing of invidious discrimination. I just don't see how Davenport says that.
Davenport also said about compactness, though, that it's a much reduced factor in New Jersey because of its our irregular shaped boundaries, which again is what Jersey City has.
I understand. And so I understand that you're saying that you have to consider reality when deciding whether something is compact. But I thought you were separately arguing that it doesn't even matter if something is compact unless you are alleging invidious discrimination. And I just don't see that requirement in Davenport or in the municipal ward law, which clearly states compactness as a separate requirement in the statute.
Well, and Davenport was privy to Professor Rioch's work, and there's nowhere in there either where the court said that some sort of statistical magic number needs to be hit. Again, you're compact as long as you're above 0.1 under the statistical analysis. So this is compact. We are compact here. There's no reason. The current map is compact. Is there other maps that couldn't maybe not be compact? I'm sure there could be. I can't hypothetically sit here and speculate as to what that would look like and when it would be not compact. What I do know is that the map that's before the court today is compact, and there's no allegations. Not only there's no showing, there's no allegations of invidious discrimination here.
Can a motion judge, a 462E motion judge, resolve whether a map is irregularly shaped at that stage in the litigation?
I believe that the motion judge here did, and correctly resolved that it satisfied the municipal ward law.
The answer is yes, right?
Yes.
How does a judge do that?
I think the judge does it as it was done here by the trial judge.
Eyeball it?
Eyeball it. Look to this court's historical interpretation of compactness. Look to this court's holdings in Davenport too. Look at the constitutionally acceptable legislative ward maps we currently have, which I would submit based on my eyeball test are less regularly shaped than the wards at issue here, and they've upheld constitutional muster and been found to be compact, presumably, or at least survived challenges to it. So again, I think that all of those factors go into it. And I think that if we allow a plaintiff to simply allege baldly, this isn't compact, I don't like the way this looks, or this looks weird to me, to go forward and conduct discovery, and it'll bog down. There's 64 different municipalities that have awards. Plus, it would have grave consequences in our legislative districting too. If there was a compactness definition set forth today as a result of these arguments that would allow a complaint or a challenge to go forward based upon just an argument that we don't like it, or we can come up with a better map, or somebody else can come up with a better map. The implications of that, I think, would be severe. And I think that that's why this court has said for the last 50 years and hung its hat on the invidious discrimination hook and a positive showing of invidious discrimination, that it was drawn in this way in order to discriminate against somebody.
Counsel, does that mean that communities of interest are relevant to your analysis?
there's been some confusion, I think, in the debate before. Communities of interest, there's a difference between irrelevant and required. I think communities of interest are relevant districting considerations.
How could they be relevant given the analysis you just gave of how a motion judge would deal with this case on a motion to dismiss, where there's no discovery, there's no additional factors, and they're just eyeballing it?
Well, I think that community of interest can be considered by an apportionment committee. The question I think here is whether or not it's required to be. I don't think that the appellate division said it couldn't be considered. They said it wasn't required to be considered. And if it's not considered, you can't say you need to consider it because it's not in the statute and there's no precedent from this court or any court saying that it should be considered in the context where there is no allegation of racial discrimination and no showing of racial discrimination. Again, this isn't a Voting Rights Act case. So again, a community of interest could be considered. If you could define it, I think when you come down to the municipal context, and a lot of the cases relied upon throughout the briefing, all involve state legislative concepts. Very few, if any, involve municipal districting. So, you know,
But if it's not required, then why is it ever even considered? If it's not something that a municipality has to look at, then why even bother? Why not just make it purely statistically based on the numbers and just on the population equality?
That could be done, Your Honor.
But Counselor, isn't the answer to Justice Noriega's question? Because if you're not treating similarly situated people equally, you're engaging in an equal protection violation and therefore triggering the constitutional impropriety that follows the notion of invidious discrimination. Isn't that the answer?
Yes, I mean, right. I mean, the population equality is necessary. In the Karcher versus Daggett case that was cited, New Jersey's congressional map was struck down. I believe it was the 1980 congressional map was struck down, even though there was only a population deviation of less than 1%, because they said that even that deviation didn't take into account other considerations. So, or it wasn't justified because there was no other, no showing that they tried to get it down to zero. So, yes, I think that could be that communities of interest are certainly do not justify a deviation from population equality as what I read this court to have said in Jackman when they said that community of interest was wholly irrelevant. And I think here we come into even greater problems as we wrestled with within the municipal context of how you even define a community of interest. So I would say that it is in the municipal context. It's certainly not required to be considered. If a apportionment committee wanted to try to consider it and they wanted to try to define it, I believe that's within their prerogative to do, but that doesn't mean it's required, and that doesn't mean it's even practical or should be, or could be done.
So it just sounds to me like you're defining compactness in the statute to mean solely shape or size. And if it's bizarrely or irregularly shaped, then the motion to dismiss should be denied. But if the map is not irregularly shaped or bizarrely shaped, the judge can grant that at least reject that argument and dismiss that aspect of the municipal ward law. And that comes down to a question of eyeballing the map. Am I right?
Yes.
And that's what the judge did here. He looked at the map, said it's, although as for the points that Justice Weiner-Apter pointed out, dealing with the shape of Ward F and A, is that a disputed issue of fact, or is that something the judge can simply adjudicate on such a motion, on a motion to dismiss for failure to state a claim?
I think the judge can and should adjudicate it on a motion to dismiss a claim. Again, compactness is a concept in districting in part because it has been, and I think the plaintiffs make this argument themselves, that compactness has historically been important because, when you have gerrymandering based on invidious discrimination, you'll have oddly shaped districts that are drawn. You'll have a line where you're trying to make sure that only certain people are in a district or certain people are packed into a district or whatever the case may be. So you can't think of compactness without thinking about that. And I think that that's why the Davenport 2 case our court put in the positive showing of invidious discrimination, and why this court in 2022 reaffirmed that, because otherwise you're always going to be able to say, oh, this isn't as compact as possible. Again, compactness is a nebulous concept, a difficult concept to articulate, which I think has been acknowledged by everybody that's who's argued today and all the briefs that have been submitted. And only if there's a showing of a positive showing of invidious discrimination should we go beyond sort of the presumption of legality for a map to question whether or not it is in fact compact, and whether or not the way it was drawn was justified.
But again, if the legislature had wanted a claim of invidious discrimination to be required in order to consider compactness, then it would not have written compactness into the law as a separate requirement. The law doesn't say anything about invidious discrimination or compactness not being necessary unless invidious discrimination is shown. And I understand that based on the federal constitution, and I had asked questions to opposing counsel about this, that based on the federal constitution, there is no independent requirement of compactness. And instead, it's just looking at compactness as a showing that invidious discrimination was actually at play. But that's just not how the legislature wrote this statute. It wrote it with compactness as an independent requirement that seemingly has nothing to do with invidious discrimination, because the statute doesn't use the word invidious discrimination at all.
Well, Your Honor, in writing the statute, though, it's a well-known statutory interpretation canon that the legislature is presumed to have known what this court has said about compactness in the exact same context for legislative districting. So the legislature did not offer a definition of compactness different from what this court had set forth in Davenport 2 and in Jackman. And so therefore, it was those.
So your argument would be that the statutory, leaving aside any constitutional requirements that may apply in other settings, that the statutory requirement of compactness should be interpreted based on what this court has historically said, which is essentially, as Justice Fiscali indicated, more of an eyeball test than a mathematical test?
Yes.
Other questions, anyone?
Just one quick one, Chief. Counsel, I guess I just don't understand. When there is a statistical analysis that can be done, why would we rely solely upon an eyeball test and not at least add to that the analysis that's been done? It feels to me like this, just purely an eyeball test, is a recipe for inconsistency and inefficiency. And what feels to me that if there, and I'm not saying, I don't know what the standard is, right? I don't know what the threshold is. But it seems to me that analysis can be complemented by a statistical analysis that has already been used, or at the very least, we should be in a position where we're submitting that REOC, or I can't, Polsby Popper, I think the name is, to some sort of a Daubert hearing subsequent to this as to whether it is appropriate. But I guess I struggle with the idea that we should stop at an eyeball test when there is actually academic analysis on this issue that is relevant to whether material decompaction occurred.
Your Honor, I would say with respect to that, again, the REOC test has been around since 1961. It was actually criticized by Polsby Popper. So we're not, it's been around since 1961. This court has never required its consideration in any of the other redistricting cases before. Professor REOC was involved in the Musto report. Again, there's no indication in the municipal ward law that the REOC test should be considered, or that there's any sort of minimum of under the REOC test that should be considered. And there's no indication that the REOC test even applies in the municipal ward context. So I don't, these mathematical measures are imperfect, admittedly by their own authors, and they criticize each other. Riak himself says compactness, is often difficult to define, and that you can deviate from compactness to take into account other considerations, such as one person, one vote. So, and again, going back, we've talked a lot about the legislative history. I just want to go back to the Musto report and page 57, which was page 57 of that report, PA 78 in the record, was cited earlier for the concept that communities of interest need to be kept together. I don't think it specifically says that. It just says that communities, the community shouldn't be unnecessarily divided when talking about smaller communities. But it does say that in considering it and why wards should be re-examined, and if necessary, their boundaries redrawn to attain equality of representation when new population data becomes available. So again, even in the Musto report that's relied upon here for legislative history, the one thing that is clear from it is the concept of population equality. And again, I would submit that interpreting, the municipal ward law, this court's prior jurisprudence, again, these are monumental cases, some of the most important cases in our state's history. I mean, there was 7 Jackman cases, and I believe there was 2 other ones that the court denied cert on. So there was like 9 Jackman cases. There was 2 Davenport cases. There was Scrimminger, where we found our own constitution to be, or where this court found our own constitution to be unconstitutional by trying to preserve county. So these issues were grappled with by this court on a annual basis for a decade before the passage of the municipal ward law. And those definitions set forth regarding compactness and those principles and guidance offered by this court should apply. And under that guidance, this map, the Jersey City map, should be upheld. And there should be the standard of deference, I think, should be applied to that.
Mr. Orlando, is there anything you'd like to add in closing?
No, Your Honor, unless there's no further questions. Thank you.
We have your position. Thank you. Mr. Greenberg, you've been very patient.
Thank you, Chief Justice Ravner. May it please the court. No one has more of an interest in a City of Jersey City ward map that fully complies with the law than the City of Jersey City. It's the most diverse city in the United States. We would reject any map that embodied invidious discrimination. But this map does not do that, and plaintiffs expressly have disclaimed, including today, any assertion that it does. This map complies with the municipal ward law and should be affirmed. The wards are indisputably contiguous. No one has argued about that today. The population deviation of 1.8% is well within the threshold of 10% that the municipal ward law establishes. And the wards are compact on their face, what Justice Hoffman and others have referred to as the eyeball test. And I'm sure we'll talk about that more. The wards are far more compact than many of the legislative districts that are also subject to a compactness requirement under our Constitution. And the appendix, I think it's DA7, shows you some of those very serpentine, very narrow districts that are drawn. Certainly, these wards are reasonably compact, which we heard from plaintiffs' counsel today is all that's required. There's no mandate in the municipal ward law, in the legislative history, or in the Musto report that the ward map has to draw a pretty picture with uniform geometric shapes or any other aesthetically pleasing aspects. Because of all that, from plaintiffs' first filing until their last, and in between, and as again we heard today, they try to argue that because of the absence of communities of interest, that these wards are not compact. Their complaint, paragraph 1, the very first paragraph, said that communities of interest are, quote, embedded into compactness. Their final submission to this court in response to the amici says that communities of interest are inherently intertwined with compactness. In between, in their petition on page 16, the plaintiffs want to have it both ways. They say, though conceptually distinct, communities of interest is a standard that is directly related to compactness. What does that mean? And how do the plaintiffs win under either scenario? If communities of interest are distinct, as the plaintiff's clause in that sentence of their petition began by saying, it can't be added by this court to the municipal ward law because this court does not rewrite statutes. If, on the other hand, communities of interest are related or embedded or intertwined, that would mean that a perfect square or circle district with communities of interest would be considered compact, but that same perfect square or circle without communities of interest would not be considered compact. That's an absurd result, I suggest respectfully to your honors, that the legislature never contemplated and never would have. The legislature, as you've heard, chose not to include communities of interest as a statutory criterion, and plaintiffs acknowledged that earlier today. That's a very telling fact, the omission of the communities of interest as a statutory criteria on its own. But it's even more compelling because other states do include communities of interest in their redistricting criteria, either in their constitution, by statute, or by guideline. And I think Justice Noriega referred to that earlier this afternoon. The ward commissions can, if they choose, consider communities of interest, assuming that they can puzzle out what a community of interest is, how it would relate. There's been a lot of colloquy today about the difficulties of even figuring out what a community of interest is. And certainly the scholarly literature that was addressed by the Ward Commission in its response to the League of Women Voters brief really brought out how difficult it is to identify what a community of interest is. And we heard questions from various of the justices about that. Nonetheless, ward commissions were given great discretion by the legislature to consider communities of interest if they wish, but the court should not mandate that because that would rewrite the municipal ward law. All that is also true of the calculations of Professor Riak. And without any disrespect
What do
to
we do, counsel, I'm sorry, with the trial court's finding that, quote, a ward can be shaped as a horseshoe or as an L, as it is here. Ward F looks like an L, maybe a boomerang, but something with a bend in it. So that even if we agree with you on communities of interest, the trial court does seem to be saying here that the ward looks like something with a boomerang in it or an L, and that's looks like a horseshoe perhaps, but that's totally fine.
I think, Justice Wayner-Apter, that the trial court misspoke when it said that a horseshoe was acceptable. This court itself has said that a horseshoe is not acceptable. It did not say, as Mr. Calderon indicated both in his brief and before your honors today, that an L shape is improper. It said that a shoelace was improper. The fact that a trial judge or anyone can characterize the shape of a district as relating to an object of some kind, whether it's a boomerang or some other object, doesn't mean that that district is less than compact. I think the issue that everyone is really struggling with today is whether there can be a single global definition of compactness that applies to all municipal ward law cases and potentially to the question of compactness under the state constitution. I don't think that there can be a single global definition that's applied in every case. And the court's own previous rulings have reflected the court's struggles to try to achieve such a thing and its recognition that it really can't be achieved. As you heard from Mr. Orlando, I think he compiled all the various discussions that this court had about compactness. The court said in one case that it was an elusive concept. In the Jackman case, the court said what is not compact, a shoelace or horseshoe. In the Davenport case, this court said that compactness, whatever it is limited where the geographic configuration of of a place, including a place like Jersey City, is oddly configured. The court also said, without reading compactness out of the statute, because it can't be read out of the statute, the court also said that population deviation is paramount to compactness. And in fact, there was some discussion earlier about what the legislative history says about compactness and about other things. Returning to page 57 of the Musto report, you heard Mr. Orlando quote this before. The only one of the three criteria that wound up in the statute, contiguity, compactness, and population deviation, the only one of those criteria that's referred to there is population deviation. That was the most important criterion referenced in the Musto report. It says wards should be re-examined and, if necessary, their boundaries redrawn to attain equality of representation when new population data become available. That's what happened here. That's not to say that compactness is not a part of the statute, but this court recognized when it said that population deviation is paramount, exactly that principle from the Musto report. That also appears in the legislative history that is attached as to the ACLU's appendix on page 12. I think it may be elsewhere in the record, where there's a summary of what this bill would do. And once again, of the three categories that were proposed and later enacted in the bill, the only one that's explicitly called out is the 10% population deviation limitation. Again, that's not to say that compactness is not part of the statute. It is. But I believe that when the legislature adopted a compactness principle, what they were talking about was, what does the district look like? What Mr. Slocum referred to, and that I agree, and the court implicitly agreed previously, was we know it when we see it. When the court said,
but Mr. Cooper, if I may interrupt you for a moment, I thought Mr. Slocum's argument was more than what the district looks like. And I don't want to attempt to paraphrase what he said, but I think the concept there was not just what it looks like, but what are the qualities of the people living on that geographical area. So I don't know that you and he are agreeing on the criteria. I think both of you would say that geography is important, very important, but I think that the argument on the other side is that we look to determine communities of interest. We look to assess compactness at what the interests of these people are, not just their demographics, but what is it that they want or don't want out of government. What's your view on that, if I am correctly interpreting what Mr. Slocum said?
With your permission, Justice Patterson, I'll address the first part of your remarks first, and then hopefully I will still remember to answer your actual question from the end.
Question, not your first long question from me. So
you are right that I don't agree completely with Mr. Slocum. Our agreement ends with the idea that the court has implicitly said that we know it when we see it. In Jackman, when the court defines some things that are not compact, that's kind of the other side of the coin of saying that we know it when we see it. We also know when we don't see it, when there's a shoelace, or where there's some other bizarre configuration that goes even beyond the legislative districts, as I indicated, some of which one looking at those districts might wonder how they might have been considered compact. They are. But that's as far as my agreement with Mr. Slocum goes, the extent to which we know it when we see it. In terms of applying communities of interest, as I've indicated, and as you heard from Mr. Orlando, the statute was carefully considered by the legislature. There were a series of amendments that's in the legislative history in the record. There was the Musto report that was prepared in part by Professor Riak and had a distinguished grouping of other people involved. This was not an ill-considered statute. The concept of communities of interest was known to people. It was not considered to be a statutory criterion, and for good reason, in my view. I don't see how communities of interest are able to be defined in a rational way that would allow for ward commissions routinely to consider them. As I said, they have the ability to consider them if they believe, based on the local conditions with which they're more familiar, that there is a way to identify communities of interest and to factor that into the redistricting calculus. But courts are not in a position to, and should not be in a position to, involve themselves in what is essentially is a political decision, as this court has repeatedly recognized, particularly in regard to communities of interest. Because as you, Justice Patterson, and others were questioning about today, people's views on particular political issues such as affordable housing or environmental remediation or any number of other issues vary person to person and are not necessarily uniform even within particular neighborhoods. So the courts would not be or should not be involved in second guessing the decision of a ward commission, whether they consider communities of interest or not. Similar to the standards in a way that we apply to a review of planning board and Board of Adjustment decisions. There's the recognition from cases like Ward versus Scott going back to the 1950s that local bodies have familiarity with particular matters that other bodies, reviewing bodies, don't have. It's not an exact parallel because the Ward Commission is not a body comprised of citizens of the municipality whose ward map is being prepared, but it's kind of a more general thing. But to return to the REAC calculations, in a case that we all remember from law school, Lochner versus New York in 1905, Oliver Wendell Holmes wrote that the 14th Amendment did not incorporate the publication Social Statics, written by a person named Herbert Spencer, that had a particular political and economic view. In the same way, the municipal ward law did not enact Professor Riach's 1961 article, though again, ward commissions can consider that if they choose. But the plaintiffs can't demand that this court add the REAC calculations to the municipal ward law. That's especially so given that even one of plaintiffs' amici, the Electoral Innovation Lab, noted that a savvy map maker could defeat Professor REAC's methods. And Polsby and Popper, who came after that, as you heard from Mr. Orlando, also criticized the REAC analysis. You heard this morning from plaintiffs' counsel that the Polsby-Popper methodology differs significantly from the REAC methodology. There are doubtless other methodologies that could be used as well. In concept, a ward commission could employ the statistical methodology. Several justices asked about that. They can employ such a methodology should they choose. But this court should not be and cannot be in the position of mandating that a particular statistical methodology be incorporated into the deliberations of a ward commission. The statutory criteria are exclusive, and it's not to overstate the case, but we all know the principle of expressio unius est exclusio ulterius. The expression of one thing is the exclusion of all others. That's not something that rides roughshod over every other statutory interpretation principle, but it is a significant one and one that this court has adopted.
I think that principle could apply to the issue of whether communities of interest are part of the consideration. But I believe the argument of the plaintiffs and the amicus supporting the plaintiffs is that by including compactness in the statute, the legislature expected a determination of compactness, and these statistical methodologies are a method of determining compactness. In other words, the fact they're not mentioned doesn't have the same import as a situation would be if the statute has A, B, C, but leaves off D, which is a consideration found in other statutes. See what I'm saying?
We do, but the bottom line, Justice Patterson, still is that in a statute that was very carefully considered, resulted from a lengthy Musto Commission report written by distinguished people, and was amended over time, there was no decision by the legislature to include communities of interest as a statutory criterion. And the reason may well...
I'm agreeing with you. I'm agreeing with that communities of interest being in a different status, but I'm talking about the methodology, the mathematical or statistical methodology of determining compactness, which is part of this discussion. That seems to me to be the omission of that from the statute when compactness is in the statute does not seem very persuasive that the legislature didn't want that particular methodology to be used. They did
I'm not
include
suggesting that the I'm sorry.
Yeah. And maybe I misunderstood your argument in that regard.
I'm not suggesting that the legislature rejected the REAC methodology or any other methodology. What I am suggesting is that there are so many methodologies that could be used, some of which are expressly critical of others, that and any of which a ward commission could choose to use in the course of their analysis. But I don't think there's a basis for this court to adopt any statistical analysis in considering what wards are compact, because I don't think the legislature, who are lay people using terms that have commonly understood meanings, as the appellate division recognized here in going to the dictionary, the legislature was contemplating what we've called, perhaps colloquially, eyeballing the districts. There was no, the ordinary thought that we all give to the term compact really is an eyeball test. A shoelace is not compact. The example Mr. Orlando gave of a barbell where you have the very thin bar in the middle that connects two wider parts of a district, that's not compact. But in general, districts are compact on this map or otherwise when they are not shaped in a way to try to have the little thin corridor of the barbell or the thin wandering pattern of the shoelace. The legislative districts that have been found to be compact and have been adopted, some of them are less than what instinctively we might consider compact.
Sorry, go ahead.
I'm sorry, Justice Hoffman.
I was just going to ask, let's assume all the facts are exactly identical to as they are, except the only difference is that there is a text that comes out. And that text is between a couple of commission members. And that text says, we are going to lose millions of dollars unless we break up this affordable housing group. Do we have a different case?
I don't know whether that goes to the colloquy that was being had with Mr. Orlando about invidious discrimination. Is that the same question or a different question? And I apologize for asking a question when it's my function to answer them and not ask them.
It's a slightly different question. The same exact facts as we are, except the text comes out. That text is between commission members, and that text says, we are going to lose millions of dollars unless we break up this affordable housing group. Do we have a different case?
I don't think that affects whether a district is compact. There may be a claim that that could be constructed that represents invidious discrimination or has the effect of invidious discrimination because your question assumes an affordable housing development. But I don't think it affects the compactness inquiry at all. And in terms of the overall definition of compactness, that's been the subject of a lot of discussion. The definition that you heard this morning from the Acker case in Colorado is not a definition that could be adopted in the context of New Jersey. That case relied on a provision of the Colorado Constitution, Article 5, Section 47, that expressly requires that, quote, each district shall be as compact in area as possible, close quote. We don't have that requirement, so the definition from Acker is not one that can be reasonably adapted to New Jersey. Again, I believe that this court is being asked to legislate a definition of compactness that's not in the statute, that the court has struggled with and addressed in different ways, admittedly, over a period since the 1960s, and that there's no way to construct a definition of compactness that is going to be reasonably applicable to every case going forward in scenarios we can't even imagine.
Counselor, in my hypo.
Oh,
you
no, I'm
would
sorry, go
not
ahead.
in my hypo, you would not have been acting on the basis of compactness. You would have been acting, the municipality would have been acting on the basis of trying to break apart a voting block. So you say that doesn't impact compactness, but in reality, what it does prove is that compactness was not the driver.
I think the question is, what makes a ward map unlawful? There are the criteria of the municipal ward law, none of which, in my view, are implicated by the circumstances of your hypothetical. There's invidious discrimination, there's Voting Rights Act matters. Those things might potentially be a basis for complaint in the hypothetical that you posed. But the fact that a district was drawn in a given way, if you divided the district in your hypothetical, Justice Hoffman, respectfully, if the new district consisted of two perfect circles, no one would say those districts are not compact. Someone could say that the districts are not valid or just based on some criterion, whether it's invidious discrimination or some other thing, but no one could, I think, reasonably, based on what we all view as being compact, no one could say that those districts are not compact.
I think they could say that those districts were not made that way for the purpose of being compact.
Well, I think that once we get into the purpose of compactness, then we're really getting into an area where courts are not well suited to review ward commission decisions in the ordinary case. In your hypothetical, there's a smoking gun text message that says, this is why we've done it. And I recognize that that's an extraordinary case. But the court's being asked today to promulgate a rule that applies not only to the ward map here from Jersey City, but also to guide the 63 other municipalities to which the municipal ward law applies. And once we get into having to read into what the purpose was in constructing wards that are compact, I think we're getting well beyond what the municipal ward law contemplated, what the criteria of the municipal ward law are, and what the fact that there's no basis for a court to do that. With the court's permission, I just want to briefly talk about the remand and the standard of review that Justice Fasciali raised and other justices. Because compactness is a statutory criterion of the municipal ward law, there can be cases brought to assert that wards generated in a particular ward map are not compact and violate the compactness requirement. In those cases, there could potentially be some sort of judicial review, although I agree largely with Mr. Orlando's suggestion that the standard of review ought to be the same as was enunciated in the constitutional cases and in the In Re congressional districting case in 2022. If there were some sort of judicial review, like the rational basis example that the appellate division used, That wouldn't be applicable to the complaint here. And this is why. The plaintiffs have asserted two potential bases for their lack of compactness claim. The first is the one that we've been discussing, the eyeball test. And in my view, the compactness of those districts, the eyeball test of compactness, is not violated by these districts. We don't have the serpentine, narrow, shoelace, barbell kind of thing. The plaintiffs, having recognized that, supplemented their argument with their second prong, which is that the wards didn't consider communities of interest. But communities of interest, as we've also discussed, is not a statutory criterion. It doesn't appear in the legislative history. It's referred to at best glancingly in the Musto report, but is not really elevated there, despite the role of Professor Riak in that report. So therefore, the second prong of the plaintiff's argument for non-compactness also doesn't support them. Therefore, there's no need for a remand or for rational basis or any other review on a remand, because the complaint simply does not state a claim for non-compactness. That's not to say that there couldn't be judicial review in a subsequent case that adequately alleges a compactness violation, but that's not this case.
You're suggesting then that we reverse that part of the appellate division's decision that directed a remand occur and uphold the order entered by the judge dismissing the municipal
Yes, Justice Vishali, I'm suggesting that the court should modify the appellate division's decision to the extent of altering that part of it that calls for a remand and otherwise affirming.
Other questions, anyone? Mr. Greenberg, anything you'd like to add?
Thank you, Chief Justice. I appreciate the court's patience and time.
Thank you. We had rebuttal reserved. Ms. Steinhagen asked for 2 minutes. Mr. Calderon asked for 1 minute. We have been quite generous with time, and we have 3 more matters today. Ms. Steinhagen, we'll give you 5 minutes, but that's it. Please go ahead. You have to unmute yourself.
Thank you very much for, wait, I'm gonna try really fast. A lot was said, and I think I have a lot to say. First, there's been a lot of talk about a risk of litigation, excessive litigation. Remember, this statute was passed in 1981. This has been going on for 30 years. This is the first challenge to a municipal ward law, and I would argue this is happening because what was usually a very neutral and non-controversial process, as we've shown you, both in the 2000 and 2010, there were very compact 6 wards in Jersey City. It is not feasible to have compact wards based on geography of Jersey City. This was a unique situation, and it was because of discrimination. I just have to say, this talk about that it's in the standard of review, that the review is only if it's invidious. This court has been dealing with, for how many, 60 years, with challenges to redistricting in the context of the legislative reapportionment, and I don't think one challenge involved a claim of racial discrimination. There's been a lot of talk again of using the notion of paramountcy of population deviation to apply what the court has found in the legislative redistricting context to the municipal ward law. I think I've tried to address that, and I will simply repeat. Jackman v. Bodine said from day one, the limited value of compactness in the context of redistricting in New Jersey is because of the existence of political subdivisions. There are no political subdivisions to be respected inside Jersey City. This notion that election districts are to be respected. Election districts they're transitory. They change after every redistricting. They are not stable. Communities of interest do not develop around election districts, meaning the polling place where you work, where you vote. In fact, please go to our complaint. We allege they use election districts because they wanted to know how people voted. I think what has been said here is that we did not allege political gerrymandering. We alleged political gerrymandering. We alleged political retaliation. This court decided not to take that matter up on certification, and I will ask for a reversal of that decision. because in fact, none of the courts below grappled with the elements of what a political retaliation claim would be. We laid out, both for the voters of New Jersey, a standard of review that other courts have used for a political retaliation claim. That was Shapiro versus McManus down in North Carolina. And we did it for election officials themselves. And so I just want to say to everybody here, we understood the decision of this court not to take cert on count 2 of our complaint, to figure out whether one could have a viable challenge simply by alleging violation of the statute itself, what we think happened, not the why it happened. But we do, and the people I represent know why it happened. I want to get to a very quick point with Justice Hoffman. You asked my colleague you read from our complaint why we looked at the use of the demographics as being irrational. Very clearly, use of racial data for redistricting is impermissible. It is irrational in this case, unless you, especially since the racial demographics of Jersey City have changed in 10 years. So there's no a priori notion that the racial demographics of the ward should change. The only reason people can use, and maybe this is what they meant to say, that they wanted to have compliance with the Voting Rights Act. But let us be clear, racial data can be used if you want to have compliance with the Voting Rights Act. But the Voting Rights Act itself requires you to create reasonably compact districts. And it also, as my colleague, Ms. Bromberg explained, in the LULAC case, it requires you to respect traditional principles of redistricting, such as communities of interest. Now, let's go back quickly. What is the purpose of redistricting? This whole conversation, it doesn't make sense if you don't understand the main purpose of redistricting is to prevent voter dilution. And the question is whether voter dilution can only occur if you don't respect population deviation. And the answer historically in every court, whether they have found it under the federal constitution or not, is that you also need continuity and compactness, because you can create equal population districts around the state within a ward, but you can have, it would be completely irrespective of compactness. Then let's take compactness. You can create very compact districts, we know, that do not consider communities of interest. It would make no sense to the purpose of creating wards in the municipality if we just had if we had regular shaped wards that didn't respect the Palisades, didn't respect natural boundaries, and didn't respect the very diverse communities that have developed. So I just want to say clearly, communities of interest is a concept. You guys, the Supreme Court, I mean, have a very well-defined concept of what communities of interest are, and one can figure them out by testimony. And that is what the redistricting process does on our state level. There is many public meetings where they garner information.
We're well beyond 5 minutes, and I think we have your point.
Okay, but you wanted me to address the shift of burden, so I will just go with that. I just wanted to say communities of interest are not viewpoint-based. They are based on infrastructure and things. Sorry.
Is there support for a rational basis standard on remand?
Okay, the answer is, what does you mean by a rational basis on limited remand? The notion of this limited remand, in fact, means that the appellate division found that we had proved sufficient deviations from compactness, that they were now sending it back to the commission to just justify it. If that's the case, that's okay to have a limited remand that way. What they were unclear about who had that burden to prove the justification. I think the state has the burden. That has to be clear. And I would accept that simply just articulating a rational basis, meaning the rational policy, the rational objective that you were trying to achieve, such as population deviation, is not sufficient. Karcher v. Daggett, because this is in the context of fundamental rights of voting, which I would argue is the reason why we have a civil rights claim here, if you find a violation of this statute, requires that you can't simply assert, We did these maps because we had to get a good population deviation.
What should the standard be? What's your position as to the appropriate standard on remand?
The appropriate standard on remand here would first to be clear that once we have found a deviation, that we're remanding it for the commission to justify its basis for not having created compact maps. And it has to show that, one, that the reason, the rational policy that they're trying to achieve is directly, specifically related to the boundaries of the map, and that no other alternative maps could have been drawn that vindicated that interest, such as population, if that is their rationale for doing it, that at the same time doesn't create better compact maps, or infeasibility. But that we know is not the case, because infeasibility in the context of Jersey City has never been the case. That might be the case in state legislative districts.
Thank you. Thank you for your response and your rebuttal. Mr. Calderon.
Yes, I'm here.
Did you want to offer a rebuttal?
I'll respond with my, yes, sir. Yes, Chief Justice, I would. So I wanted to touch a couple points that was mentioned throughout the day. First one is the definition of compact. So we have a definition from the appellate court, which is the Merriam-Webster definition, stating having a dense structure or parts or units closely packed or joined and occupying a position of efficient use of space. So that's the dictionary definition that the appellate court wants us to adhere to. I proposed in my appendix on PA 198 of Exhibit F, People versus Thompson of the Illinois Supreme Court. And it states, the word compact has different meanings as given by standard lexicographers according to the subject in connection with which it is used. It is defined as meaning closely and firmly united as the parts or particulars of solid bodies. When we look at the map on PA 24 of my appendix, we see that Ward F is that shoestring that council has spoke about before. And we see that Ward A is a horseshoe. Bush v. Vera in the Supreme Court states, we, however, already found that all three districts are bizarrely shaped and far from compact, and that those characteristics are predominantly attributable to gerrymandering, and that's at 979 Bush v. Vera. So pretty much the Supreme Court of the United States states here that bizarrely shaped districts, whether it be wards or congressional districts, are gerrymandering, which is illegal. Further, I want to point out that the Innovation Lab, the Princeton Gerrymandering, states in its amicus brief that a perfect compact area is a circle. So that's our starting basis. That's our 100% compact area is a circle. So we look at this map and we look at Ward F, and maybe council is fogged by the billables that Jersey City is offering him and cannot see what we all see, all 7 honors see, and everybody else sees, that Ward F is built like an L and it's skinny out to the waterfront. And maybe council cannot see that Ward A is a horseshoe, because I think we're looking at the same map on PA 24 in Exhibit F. Furthermore, we, as stated by council and by the Ward Commission report, we have 1.8 deviation of population. That gives us 8.2% of population deviation that we can manage before we get to the 10% threshold stated by the law. And it's the obligation of the commission to follow the law. The statute does not state that one prong is more important than the other. I understand Davenport says that it is paramount, but it also states that it's only paramount when bizarrely shaped districts do not exist, which is the case here in the 2022 ward map of Jersey City. We have 2 bizarrely shaped districts, Ward F and Ward A. Plain and simple, they are bizarrely shaped. That can't be ignored. And in regards to the constitutional deficiency, this map, or I'm sorry, this statute is created from the New Jersey Constitution, Article 4, Section 2, Line 3, where it states that districts need, in this case in the Constitution, it speaks to assembly districts, need to be nearly as compact as possible. So the municipal ward law mimics the Constitution in using compact as a prong to follow this law. So it's up to this Supreme Court, these 7 judges, to look at it and state whether or not Ward F is bizarrely shaped, whether Ward A is bizarrely shaped. It's either a yes or a no. And if they are bizarrely shaped, then we need to follow case law, which is Jackman Bodine, stating that bizarrely shaped districts will not be tolerated. The same thing that Davenport says, the same thing that Bush v. Vera says. And with that, I thank the court for their time. I appreciate this opportunity to stand before you. Thank you.
Thank you, Mr. Calderon. It's been a long day, but it's a pleasure to hear from advocates who are as well-versed and well-prepared as the group that we heard from today. And I want to thank all of you. We will take the matter under advisement.